deal with the matter of West Another and Stockport NHS Foundation Trust. Part 2.
If it pleases your lordships, my lord, before turning back to the substance, just two matters of procedural housekeeping, if I may. The first is your lordships may have noticed, I don't know if it's been brought to your attention, that there have been 3 additions to the authorities bundle. They may be provided separately on your lordship's bench, or they may. I think they've actually been included in the bundles by now. Lords, I'll take your lordships to them in the appropriate course, but just to identify them, and they're there by agreement between the parties. The first is the decision of this court in the case of Harrison, which was referred to during exchanges between bar and bench yesterday. The second, and indeed the second and third really go together. The second is the government's response to Lord Justice Jackson's report, which we considered would be of assistance to the court in relation to the question of proportionality, what the intention was, the reversal of lands, etc., etc. And the third is the explanatory memorandum to the 2013 Civil Procedure Amendment rules, which were the rules which introduced those changes, again, which the parties consider may provide the court with helpful information as to the intention and purpose behind those rules.
So Harrison is the cost budgeting one, is that right?
Harrison is the cost budgeting case, my lord, yes. And there's one paragraph in that which may be material to your lordship's determination, which I'll take your lordship to in due course. And Lord, the second point is a rather more controversial point, perhaps. Your lordships may have received, I certainly received just a few minutes ago, a 12-page document from my learned friends entitled Appellant's Summary of the Report. I haven't had a chance to read it. It was literally handed to me as I came into the court. It's very late in the day. We say the court should simply disregard it, but if the court is to accept it, then plainly I would need an opportunity to consider it and a chance to respond if necessary. So perhaps I'll leave it to Mr Bacon to deal with that as and when your lordship thinks it's appropriate to do so. Lord, subject to that, if I can return to the points in issue, obviously the 2 core points the court is concerned with is the correct approach to reasonableness and proportionality. Before I do so, if I can just perhaps deal with some short points which arose from the exchanges yesterday. Lord, the first is that a point rose yesterday about the question of the benefit that after the event insurance provides to defendants. And it arose during the course of an exchange between my Lord Justice Irwin and Mr Bacon, at which point I rose briefly. In short, Lord, the point in relation to that is that the position before the LASPO changes, before April 2013, is that it was said that after the event insurance provided a benefit to defendants, particularly in personal injury cases, because they often faced claimants who were generally impecunious, or at least certainly not in a position to meet large orders for costs. And therefore there was a benefit to defendants because if they were wholly successful in a case and got a costs order in their favour because the claim had failed, those costs would be met by the ATE insurer, whereas if there wasn't ATE insurance, those costs might not be met at all, or they might face a difficult position seeking to enforce those costs. That, of course, was said to be some justification for the old scheme, but the old scheme, for the reasons we're all, I think, aware of, was considered not to be adequate, not least because even for that benefit, a high price was being paid, because, of course, the defendants were not just meeting the cost of the actual cover, they were meeting the cost of the profits and commissions and various other things that went into it. So it was a high price to pay for the benefit. Post-LASPO, that position has materially changed. And the reason for that, of course, is the introduction of COX, qualified one-way cost shifting. So in personal injury claims generally, including clinical negligence, a defendant cannot usually enforce a costs order against a claimant, save to the extent that that claimant recovers damages and interest in that case. So, if a claim by a claimant is wholly unsuccessful, the defendant cannot enforce their costs order, therefore there is no need for adverse costs indemnity to cover that situation, the ATE doesn't provide for it, and the defendant is left without their costs. And that was the quid pro quo for the revocation of Section 29 of the Access to Justice Act and the recoverability of ATE premiums. There are circumstances where defendants can recover their costs. For example, if a claim is found to be fundamentally dishonest or is struck out as abusive, but for obvious reasons, an ATE policy, even if it provided adverse cost cover, would be unlikely to respond in such situations. So the key residual cover that remains, beyond the cover that's provided to the claimant in respect of their own expert reports and their own disbursements, the key residual cover that remains is cover for adverse costs in a situation where there is an interlocutory costs order of some kind in the defendant's favour, or where the defendant makes a Part 36 offer which the claimant doesn't beat. So that the case is one where the claimant has succeeded, but there are adverse costs orders in the process. There, some ATE policies certainly will provide adverse cost cover in respect of those costs. But the core point to note is that the benefit of that adverse cost cover in that situation is not a benefit to the defendant, it is a benefit to the claimant. Because the defendant would in any event have been entitled to set those costs off against damages and interest awarded to the claimant.
In their entirety or in part? Does that not depend on the amount of recovery by the claimant?
My Lord, it does, but the defendant's ability to recover its costs is capped at the limit of damages and interest. So say the claimant was awarded £20,000 in damages and interest.
Yeah.
The defendant had an interlocutory costs order for £50,000. The defendant could enforce that adverse costs order up to the £20,000 by wiping out the claimant's damages. And if the defendant's costs went beyond that, the defendant couldn't enforce them against the claimant.
But if there's an ATE policy to cover the defendant's costs,
My Lord, that would
why should the cap operate?
because that would only respond to the claimant's liability. It's an indemnity, it responds to the claimant's liability. There is no enforceable liability against the claimant, so there is nothing for the ATE to respond to. So because of that, the core adverse cost benefit that remains under ATE policies, the purpose of it is to ring-fence the claimant's damages, so that if there are adverse costs in a successful claim, instead of the defendant taking the money out of the claimant's damages, the defendant gets paid by the ATE insurer. Now the beneficiary of that is the claimant and not the defendant. So I simply raise the point because it was raised yesterday and it's part of the general argument that ATE should in some way be treated differently, not just for the other policy points that Mr Bacon's raised, which I'll deal with, but because in some way there is a fundamental material benefit to defendants arising out of this, which therefore we should be expected to pay a greater sum than we might otherwise have been expected to pay for. And so we would make the point that that is not fundamentally the position post-April 2013. The position, of course, simply is, as the regulations provide, that insofar as the cover under that policy relates to expert reports on liability and causation, my client must meet the reasonable and proportionate cost of that cover. Lord, the second point, which is material again to general observations made by the claimants in this matter, is what we have referred to paragraph 74 onwards of the skeleton argument in the Demouilpied case as the fear factor. And what I mean by that, my Lord, is generally the idea, and it arises from really four separate points, which I'll touch on very quickly, that because of a concern about the response of ATE insurers or the viability of ATE insurers in this market, that the court should in some way treat this item of costs materially differently from other items of costs. And my Lord, in relation to that, we would simply note the following 4 points. The first is by reference to the assessor's report, which your Lordships have behind tab 3 of the first appeal bundle. And my Lord, within that, and it may be that...
I'm wondering where this goes to, because at the end of the day, the analysis we've got to, this didn't feature at all.
Sorry,
This point didn't feature at all by the time we've worked out in our exchanges
my Lord,
with Mr Bacon how one should treat the ATE premium in terms of reasonableness and proportionality. This didn't feature at all in the analysis.
My Lord, if it's not a point that concerns your Lordships following the exchange between bar and bench, then I can simply...
No, we don't need to.
My Lord, in those circumstances, I'll simply leave your Lordships, in the event that it becomes relevant at any point, your determination following submissions with a reference to paragraph 74 of my skeleton argument, and two very, very short references. The one was the point which I think was addressed yesterday in exchanges between myself and the Lord Justice Coulson as to the caution to be attached to any reference to the fact that LAMP have now left the market. We simply don't know the reasons for that. They're a general insurer, and there are myriad reasons why they may have left. We have no evidence on it, and we can't attach any weight to it.
Yes.
The second point, and the references to it in the assessor's report are paragraphs 220, 21 and 235, is the point about ARAG having to date made no underwriting profit in relation to their book on these matters. And we would simply highlight the conclusion that the assessors drew, which was that they could say no more in relation to that, than the position was uncertain and there was some legitimate concern. But we don't know. ARAG have books of cases. The detail is in the report as to how they account to a certain extent. We know these cases have a relatively long tail, and at the moment the position as to whether an ultimate profit will or will not be made is not clear. So, my Lord, beyond that, if I can come back one further point before turning to the issues on reasonableness and proportionality. In the course of exchanges with the bench yesterday, I took your Lordships to the relevant parts of the addendum and skeleton, which dealt with what we said are material matters arising out of the assessor's report that we invite this court to make conclusions on. And as your Lordship will recall, the basis of that is that we said that the fact-finding hearing before the assessors had been teed up as a Rogers-type hearing, where the relevant facts and matters that were identified there would be the subject of full argument before this court, which we have set out, firstly in our submissions to the assessors, and secondly in our skeleton argument. Lord, we do say that those are important points which we do invite this court to deal with. In particular, there are at least 3 points which, if they are not resolved by this court now, will have to be resolved in due course, and this court
Speaking for myself, I'm really keen to hear you on reasonableness and proportionality. I think in the exchanges that we've had, we've made it clear that that's what we think this appeal is about. It's not, we think, chasing down random points that fall out of a 70-page report. There may be inter rem points where, if you don't deal with this, there may be a problem in the future, but we have to try and nail this back to what these appeals are really all about.
Well, my Lord, I can only make the point and invite the court to do so. And if the court doesn't accept my invitation, of course, then I have to follow the direction that the court gives.
Well, I don't think you're adding anything new on this point to what you said yesterday. You're saying, you regard these as important points. You've taken us to the appropriate part of your skeleton argument and the addendum. You're not, I don't think, adding anything new. You're just reinforcing their important points.
Well, my Lord, I am repeating the invitation to the court to deal with them, and I appear to be giving a repeat of my invitation being declined.
Well, we'll consider your submissions, of course.
My Lord, of course. My Lord, can I then turn, and I'll deal with them. I appreciate that, if I can put it this way, the court's prime concern, but not sole concern, appears to be the question of proportionality. But nevertheless, I'll deal firstly, if I may, with the question of reasonableness, to the extent not already dealt with. Not least because I think it's generally accepted, at least pre-April 2013, and probably even more so post, to use the words of Lord Justice Brooke, that reasonableness is a necessary precondition of proportionality. So it comes first in the questions that we have to address. And that reference for your Lordship is paragraph 104 of the Rogers case.
Mr. Manager, could I ask you to speak as loudly as you can?
I apologise,
This
my
is
Lord.
a very dead space.
Of course. Of course, and I'm a little further away than Mr. Bacon, so I'll do the best I can, my Lord. But if I'm not clear, please do let me know.
Thank you.
But also, the trouble with that particular position is there's noise from the outside, which
my Lord, as I say, I will do my best. So, my Lord, the position here, the basic position is very simple. It's not disputed that a test of reasonableness applies. The key issue really is the one about threshold. What does a defendant have to do in order to adequately raise an issue for the court to determine, and then how should the court determine that issue? And my Lord, to deal with that,
Can I just, before, so to make sure I cover all the points, just ask you this question. I mean, there are three elements: necessity, reasonableness, and proportionality. They come into 44.2a. So we've got the three different elements. What do you understand to be embraced by the word necessity?
well, my Lord, perhaps I can.
Or have I taken you out of line of your
Lord,
submissions?
not at all. It was a point I was going to come to very shortly. If we can deal with this, perhaps, I was going to go to the authorities bundle anyway, and behind tab 4 in that bundle, you have the relevant rule of the CPR, which we will come to on a number of points.
Yes.
But to deal immediately with your Lordship's question,
Yes, thank you.
the test of necessity prior to April 2013 formed no part of the rule itself, but was a creature created by virtue of a decision of this court in Lowndes and the Home Office. The rule referred to reasonableness and proportionality, and those were the two criteria that the court had to apply. This court in Lowndes, Lord Wolfe, held that proportionality needed in essence further definition and was to be defined by reference to the test of necessity. If it's necessary, it is proportionate. Now, we would say, coming to 44.3, which is in front of you on the first page behind tab 4, that the test remains: are the costs reasonable and are the costs proportionate? Those are the two tests the court has to apply. Necessity is not part of the test. The reason that there is a reference to necessity in 44.3 subparagraph 2 is because it is there to make the point that the old position that proportionality was to be judged by reference to necessity no longer applies. It is not there to make this a threefold test.
So you say it's there to make clear that the Lowndes
Lord, yes.
test,
Yes.
it no longer applies.
No longer applies. So pre-April 2013, the rule said costs must be reasonable and proportionate, but the case law said, if necessary, it is proportionate. Following the rule amendments, the rules say costs must be reasonable and proportionate, but they then deal with Lowndes by saying it's no longer good enough to satisfy proportionality by saying that they were necessary. Even if they were necessary, they may still be disproportionate. But the test remains reasonableness and proportionality.
So your answer to the Master of the Rolls question is it's still a two element test: reasonableness and proportionality.
Indeed.
Yeah.
But that also answers my point that necessity here isn't making a comparative reference to things like issue fees. It's not dealing with that at all.
Lord, no.
I see.
Putting this another way, the reference to necessity would be unnecessary were it not for the fact that it is there to make clear that necessary is no longer the test.
Yes, I see.
It would be hard to think of something that where it was reasonable but not necessary. Sorry, it would be hard to think that necessary wasn't a narrower test than reasonable anyway.
Indeed. Necessary, of course, was always meant to set a higher standard than reasonable. Yep. So a little bit like the point that I took from Lord Justice Brooke in Rogers, where it was said that reasonableness is a precondition of proportionality. Essentially, I think it probably could be said the same in relation to necessity, that something was likely to be reasonable but not necessary, but it's hard to see how it would be the other way around.
Anyway, thank you, you've answered that question.
So, Lord, I'm grateful. So, within that same bundle, I outlined my submissions on reasonableness yesterday, and your Lordship indicated that at some point I would take your Lordships to the cases which might be said to indicate to the contrary. And if I can take your Lordship straight to tab 7, Rogers and Murphy Tidwell.
You're on the threshold question.
Lord,
So
yes,
what is the threshold?
I'm on, exactly so.
Yeah.
I'm on the question of what do my clients have to do in order to raise an issue or a doubt as to the reasonableness, unreasonableness, of an after-the-event insurance premium.
Well, I think more accurately, it should be what is the threshold in order to cast on the defendant the obligation to justify.
The claimant, my Lord, yes.
On the claimant to justify the claim. It's not just raising an issue, it's actually transferring the evidential or argument burden to the other side.
My Lord, yes, I may be accused of dancing on the head of a pin, but in our submission, once there is a genuine issue before the court as to the reasonableness of something, then because this is a standard basis assessment, the burden is cast on the claimant. It's always for the claimant to justify the reasonableness of their costs if there is an issue as to their reasonableness.
I think we are dancing on the head of pins.
Lord, I'll come to the substance. My Lord, in terms of the case itself, we've already looked at this. If we can come to page 827, internal pagination. So, Lord, what we have here, we have the part at paragraph 105, which we did the first part of 105, which we've looked at. I don't need to delay there because the point there as to necessity, meaning that an AT premium must be adjudged a proportionate expense, I think is accepted in itself to no longer be the applicable test because of the reversal of allowance courtesy of the amendments to the civil procedure rules. The next point that Mr Bacon took from this case, which I'll come to in a little more detail when we come to the point on proportionality, is the argument that he says what paragraphs 105 through to 108 show is that when considering proportionality, the court must take into account all the circumstances, which goes materially beyond the circumstances of the individual case. Now that's really an argument in relation to proportionality, and I'll come back to it shortly when I come to proportionality. But just to flag up, our position is that that fails to give proper account to the effect of the introduction of CPR 44.5 subparagraph 3, which your Lordship will no doubt recall is the section of the rule which says costs are proportionate if ... and I'll come to my argument on that shortly. But, my Lord, more fundamentally for present purposes in terms of reasonableness, if we come over the page to 117, this is the point in relation to, 116 to 117, procedure to be followed in the future and evidence justifying the ATE premium claimed. Now this is the genesis of the observations, which we'll also come to in the judgment in Chris Motors in a few moments, that there is an evidential burden on the defendant to raise a point, and indeed that evidential burden may require expert evidence. Now, in that regard, my Lord, our response to that, as I think your Lordships are aware from yesterday, is that we accept in principle that it is for us to raise an issue in challenging an ATE premium. But what we say, and this is repetition of my submissions yesterday, but what we say is that precisely how that must be raised and what the evidence is that is necessary to raise that is a matter of fact and degree depending on the circumstances of the particular case. And that is the position regardless of whether the premium is block rated. So, for example, I gave...
Right, you're going over submissions you made before. You've got this.
My Lord, yes. Well, my Lord, perhaps if I can come then to the point that's often cited against us, the case that's often cited against us on this, which of course is not a decision binding on this court, but it's been cited many times, which is behind tab 10, which is the decision of Mr Justice Simon sitting with Master Campbell and Mr Vasey as assessors in a case called Chris Motors. And Lord, this is a case where there was a bespoke after the event insurance premium taken out relatively late in the day in proceedings, and the facts are at paragraph 15, and there was a challenge to that premium. Mr Justice Simon, at paragraph 35 in his judgment, your Lordship will see the reference, which isn't a matter in issue, the obvious point going back to the decision of this court in Calloway and Gray, where this court rejected Master O'Hare's proposal that there should be a presumption in favour of the reasonableness of an AT premium. So there's no presumption that such a policy, the cost of such policy, is reasonable. But then, having considered Rogers, at paragraph 43 onwards, over on page 630, Mr Justice Simon considered how to deal with the question of threshold. And at paragraph 44, as your Lordships will see, he concluded that there was an evidential burden on the paying party to advance at least some material. He refers to Rogers, and then he notes about halfway through that paragraph, where a real issue was raised, the court envisaged the hearing of expert evidence as to the reasonableness of the charge. If an issue arises, it must be raised by the paying party. This is not to reverse the burden of proof. If, having heard the evidence and argument, there is still a doubt about the reasonableness, it must be resolved in favour of the paying party. And in that case, because no evidence had been deployed, and there had been no request for further information, there was no basis on which the Master's conclusion that the premium was recoverable in full could properly have been challenged. Just to finish off your Lordship's note, paragraph 46, he refers to the vigorous debate. Judgment should not be seen as discouraging challenges, for so long as such premiums may be recoverable, but such challenges must be resolved on the basis of evidence and analysis rather than assertion and counter-assertion. And my Lord, in response to that, in broad principle, as I've already indicated, we don't dispute that it is for us to raise an issue. But for the reasons I've already given the court, we don't accept that it is necessary for that to be by way of expert evidence. And indeed, this dicta doesn't in fact go that far. It simply refers back to Rogers, where the question was if there was a challenge to the basis on which the underwriter had acted, that was likely to require expert evidence. And there may be circumstances, though we say it would be in fact very rare, where expert evidence was either required or indeed available. But in the majority of these cases, we say that there are circumstances, even with block-rated policies, where there may be issues which can be raised as to the reasonableness or proportionality of that charge without requiring expert evidence. Those issues could arise, for example, simply on the evidence that the claimant has disclosed. If there's something anomalous in the schedule or the policy that accompanies it, which indicates that there's some basis for disputing the reasonableness of the sum claimed.
Sorry, I missed that.
Sorry, my Lord, if there's something on the face of the policy schedule or something in the terms of the policy, if they're made available, which indicates that there's a reason for doubting the reasonableness of the premium charge.
Again, I think these are the points you made yesterday.
My Lord, they are, but they are important points, because what we say the claimants are seeking to do is say with block-rated premiums, the only way you can ever challenge these is through expert evidence. And that is setting, we would say, in practical terms, both an unnecessary and, in effect, an impossible threshold.
Yes.
And it's seeking to put these premiums beyond challenge, even where there are matters which might warrant such challenge. And we would say, I appreciate this court isn't going to resolve those issues in this hearing, but there are live issues in relation to these premiums, which will have to be resolved on another occasion, which have no need for expert evidence. For example, the facts are now clear.
For example,
My Lord, the facts are now clear. The outcome of the argument may not be, but the facts are clear that all of these premiums are calculated on the basis that they self-insure. Now, there's a straight legal argument as to whether or not that is permissible. That doesn't require expert evidence. The evidence indicates that in at least a number of these premiums, part of the cost that forms the calculation of the premium relates to agency fees. They're included in some of the expert costs. Now, there's a straight legal argument as to whether it is permissible under the legislation to claim against a defendant part of the cost to this case, which doesn't relate to the expert report itself, but to what are in effect profit costs, be it of an agent or otherwise, involved in the obtaining of that report. That doesn't require expert evidence. It's a matter that's arisen on a consideration of the facts, which requires a judicial determination.
well, it might require expert evidence if the challenge is to the payment of such fees in any relevant discipline. If the market in experts is shown to have moved so that all experts regularly involved operate through agencies. That
Well,
might require.
there may be more than one argument in relation to that, but there would still remain a primary argument as to whether it was permissible per se. If it's simply outside the scope of the legislation, then frankly, market practice is irrelevant.
In any event, your point is that there may be examples where you don't
Yes.
need expert evidence, but if it's a challenge to the market, which is what is essentially offered here, that's bound to involve expert evidence.
Well, my Lord, no. And we would say here, of course, our point is and always has been that this isn't a challenge, for example. It's not been any part of our case. Mr. Bacon's made the point many times that I've not put this to witnesses, and he's absolutely right about this. It's not been part of my case to say, for example, to Mr. Haynes, that the sum of your practice is not consistent with the practice of an underwriter complying with his professional obligations. I've not put that to him, and that's not been our case. Our case has simply been, in relation to these cases, certainly as far as reasonableness was concerned, that there was evidence before the court that other claimants in similar situations had been able to obtain policies which appeared to provide a similar level of cover, because they all are directed to the same thing, at a cheaper cost, and that therefore there was an issue as to the reasonableness of the cost in this case. Now we say, again, that is not an issue which requires expert evidence. The court can consider that evidence.
It
if
may
thinks
do.
it's-
It
Sorry,
may
Lord.
do. It may do, because in all cases, or all disputes, should I say, that involve comparators, then sometimes people say, well, this is a reasonable comparator because, and the other side say, no, it's not a reasonable comparator because, and very often the judge says, well, this is not something that I know about, and therefore I could only decide it by way of expert evidence. So it would depend on the underlying dispute.
Oh,
They're not
well,
in separate all I'm saying is they're not in separate boxes.
Lord, I'm not seeking to rule out, though I say it would be a rare event and in practical terms probably very difficult to obtain because of the nature of the market. What you have on one side is 80 insurers, what you have on the other side is defendants. And the 80 insurers, where it could be said that there was no independent expert evidence before the assessors below, but where it could be said the expertise lies, are of course in the camp of those seeking to support the recoverability of the premiums. But in any event, I'm not seeking to rule out absolutely the prospect that expert evidence could be required in certain circumstances. But what we're talking about here, of course, is AT insurance. Back when Rogers was dealt with, AT insurance was in its relative infancy, certainly when the policies in those cases were taken out. The courts have now had 20 years of experience of dealing with these things. The market that the courts now have to deal with in terms of recoverability is a very limited and very narrow market. The court doesn't have to deal with AT insurance from a whole range of different areas. It has to deal with this one narrow area. It will ultimately be for a judge, we say, and this comes back to the main point, it will be for a judge to decide whether on the matters before him on the facts before him, on such documentation as is before him, whether it's from the claimant that's said to indicate a flaw, whether it's by way of comparators, whether it's by way of witness evidence, whatever it is, whether that raises a sufficient issue which he is capable of determination. But we would say, and we'll see an example in a moment, that the Surrey case was a block-rated policy case, where two very experienced cost judges in separate cases considered themselves able to intervene and reduce the premium that was claimed, because they were satisfied, not because of any evidence from defendants, but because of matters raised on the face of the policy schedule and in those cases, the facts of the case, that there was sufficient for them to be able to intervene and use their experience and judgment and knowledge to say that the premium was too high and it should be allowed at a lower level. Now, subject to coming back to the facts of these cases, which obviously I'll have to do at some point, dealing with the question of principle, that's as far as we go. We simply say that the attempt to set a mandatory threshold that applies in every case simply because the premiums are block rated is wrong and would seek to deny us the opportunity to challenge these cases if a proper challenge could be identified.
Yes, thank you.
Well, because I've indicated it, in fact the Surrey case is behind the very next tab. I'll just take your lordships very briefly to the point. It's a decision of Mr Justice Foskett. Your lordships may be familiar with this case, and certainly in the name of the case, because it came to this court on an appeal from Mr Justice Foskett's decision on the change of funding issue. So the case was primarily about claimants swapping from legal aid to CFAs with ATE, and therefore increasing the costs, liabilities pre-April 2013 to defendants.
The relevant bit for our purposes is paragraph 116.
My Lord, yes, 111 and in particular 116. But your lordships have there, as I say, these were block rated policies. There were three cases. In two of them, Surrey and AH, the premiums were reduced by two different experienced cost judges, Master Rowley and Deputy Master Campbell, very experienced cost judges. In one case, as we can see at 111, the reduction was from 50 odd thousand to 30 odd thousand, and in the other it was from 18 odd thousand to 15 odd thousand. And the reason for that reduction in those cases, and it's different to the reduction here, is that even though they were block rated, as we can see from the top of page 530, which is an extract from Master Rowley's judgment, the view was taken that the level of cover provided on a block rated basis was excessive, and that had a more reasonable level of cover been chosen, the premium was likely to have been cheaper. And that's the indented part, paragraph 109, towards the top of page 530. Interestingly, in the Campbell case, in the AH case dealt with by Master Campbell, one of the longest serving of the cost judges, he formed a similar view, and if your lordship sees at paragraph 85, he's directed to Chris Motors and Rogers, and he notes that he agrees with Mr Marvin that when the premium is challenged, the paying party must produce material.
85?
Indented 85. Sorry, my lord. It's between
Also
paragraph
114.
I'm grateful. Thank you, my lord. Bottom of paragraph 114, quotation at 85. Now there was none, so there was no material produced by the paying party, but that was of course because the nature of the challenge arose from what was on the face of the documentation that the claimant had produced. And at 118, Mr Justice Foskett, and his decision on this part was not appealed and was not overturned by this court for obvious reasons, given the lack of an appeal. He made reference at 117 to two decisions which I think we've touched on, Mr Justice Aikenhead and Master Hurst. Both of those, I'll take the point straight on the chin, were not block rated policies, but nevertheless they were examples of the court reducing ATE policies without the need for any detailed evidence. And at 118, Mr Justice Foskett noted that the application of any broad brush must not be a capricious exercise, but he refers to the experience gained by cost judges and the need for them to retain an ability to engage and be permitted to enter the arena. And we would say that is an important point. It goes to a point raised by my Lord Master of the Rolls, which was really how is this all to work, and how do we deal with making sure that there is some effective control on these premiums? because the point that can be seen, and it's a point that has been made by the assessors in their report, paragraphs 195 through to 198, where they note that despite having conducted the fact-finding exercise, there is little evidence that the market provides any competitive downward pressure on the cost of premiums. There's little evidence that solicitors have any incentive to review the schemes that they've signed up to. There is a lack of evidence to show that clients were made aware that other schemes were out there and existed, which might have cheaper premiums. So this is not, now that the fact-finding exercise has been carried out, there is no evidence that this is a market that self-regulates or provides any downward pressure of its own, whether through the insurers or the solicitors. The control over this and the control that's been put over this is controlled by the courts. Now that might be a control that the courts frankly would rather do without, and that could be understood, but that is the control that is there. And it must have some valid effect and purpose, and the judges must be able to decide, is there a valid challenge in front of us, and if there is, we can use our experience and judgment and knowledge, if we consider it appropriate to do so, to intervene and if necessary reduce the premium if we are satisfied it is unreasonable, or if we are left with a doubt as to whether it is reasonable.
Right, can we just go back to indented 85?
Well, yes.
In paragraph 114. I may have misunderstood this. The cost judge, is this right, said that he agreed that when the premium is challenged, the paying party must produce material to support any attack on its level.
Yes,
what do you say about that?
Well, my Lord, I think if we take what he says as a whole, it makes more sense. If you read that sentence in isolation, I would disagree with it.
Right.
What I say is that there must be some material before the court which raises an issue, and as I've indicated, that can come from a variety of sources. And indeed, I would say if we take paragraph 85 as a whole, that is in effect what the very experienced cost judge is doing. He's saying there's no material from the defendant, but on the facts of the case in front of him and what he has seen, nevertheless there is an issue which raises a doubt which he resolves in favour of the paying party.
The point there was a straightforward one. The claimant had over-insured.
Well, not necessarily straightforward in the contents of block-rated policies, because of course what's said in relation to block-rated policies is that the precise limits of indemnity.
Sorry to break in, but the cost of the overinsurance may be complex, but it's just, the point was straightforward. He had already got legal aid cover, and legal aid for some of the costs. $500,000 was too high.
Yes, but my Lord, what the judges did not require was, for example, detailed evidence, let alone detailed expert evidence, as to how often the full limit of the indemnity under these policies is called on, whether the full indemnity has any direct materiality to the level of premium, all of those matters. What the judges concluded was, exercising what was ultimately a relatively broad brush, was that a sufficient issue was raised to create a doubt, which the claimants had not dispelled, which the judge therefore had to wrestle with and reach a conclusion as to what he should do with the premium.
So ultimately, I mean, it's a relatively straightforward debate between you. Mr. Bacon would ring fence the AT premium. You would deal with everything on a case-by-case basis.
Well, Lord, ultimately, yes.
I mean, that's the dispute.
Yes.
And you say that on that basis it should be left up to the individual DJ and his individual, her individual experience.
Lord, yes. Like any other item of cost.
That's not really control.
Well, Lord, we would say it is. There is no
different judges have different experience.
There
for one
is,
thing.
Well, they do.
There would, on this basis, there would be no rules or guidance. It would just be do your best on your experience.
Lord, guidance would, of course, always be welcome, and of course, there used to be guidance in relation to AT premiums. It didn't cover all of the issues by any means. But there used to be some guidance in this regard in the old cost practice direction, which your lordships have behind tab 6. And that indicated, as your lordships may know, in paragraph 11.10, that in deciding whether the cost of insurance cover is reasonable, there are a list of relevant factors that the court should take into account. And those included the level and extent of cover provided, amounts of commission, and various terms of policy, such as whether any of the premium will be rebated. And those were express matters that the courts were enjoined.
We started off this particular run of your submissions by dealing with the issue which I thought you were dealing with by reference to these cases, of making the submission that you don't accept that in the usual run of matters it was for the paying party to adduce expert evidence.
Lord, yes.
I thought that's where we started. We then seem to have merged into control mechanism, and now we're merging into another issue. What actually is the issue you're addressing at the moment?
Well, Lord, the issue I'm addressing is the question of threshold.
Right, can I just then deal with that, because I'm still on that.
Well, Lord, of course.
Right. So I just want to understand, I understand what is the general position. I mean, the impression that I get from reading this 2018 case is that, subject to, I know your points about this, but that in this case of AH referred to in paragraph 114, it looks to me as though at the moment the cost judge is saying that if there's a point that's being raised that appears to be a material point on the reasonableness of the policy about claim or proportionality, in other words, if it's not a case which he can just dismiss out of hand, but it's a serious point, that he is, certainly in that first sentence of indented paragraph 85, he says that the paying party must produce materials to support the attack, and then he refers back for that to the Chris case, isn't that right?
He does.
And that again, you said you don't agree with it, but that is what it appears on the face of it. They're saying in the Chris case. I know you don't agree with that, but at least that's one reading of the report. So what I'm interested in, from your experience, because you're obviously, like Mr. Bacon, a person who deals a lot with this sort of issue, what actually is the general practice among district judges, cost judges, on this issue? Do they tend to follow that line or not?
Well, look, my experience is that judges will require the defendant to raise an issue, but those issues have been raised, as I say, for example, by reference to information that has been provided by the claimant, or possibly information that is asked and provided by the claimant through Part 18 requests. There are cases where the issue is raised by virtue of the defendant producing some form of evidence, and I have to accept there are cases where the judges say that despite what the defendant says, no adequate issue has been raised. But as a matter of practice, we would say it depends on the facts of the case and the judge deciding, by reference to what is in front of him, whether an adequate issue has been raised.
Well, that an adequate issue, because it's the paying party who raises the issue,
Yes.
means, as I understand it, an issue which can't simply be dismissed out of hand.
Well, yes. The expression that's used in other areas of costs. So, for example, if there's a challenge to CFAs, the expression that's sometimes used is a genuine issue. So, if the court is satisfied that there is an issue before it which properly requires determination.
Right. So I think what you're saying is, generally speaking, depending on the issue, the cost judges first of all consider is the objection by the paying party a genuine one?
Yes.
If they decide it's not a genuine one, they'll just dismiss that completely.
Yes.
If they decide it's a genuine one, then at the moment it looks to me as though from Chris and from the AH case, only at the district judge level, cost judge level, as though the cost judge then says, okay, there's a serious issue here, I may require, or depending on the circumstances, I require a bit more from the paying party than simply an assertion.
Well,
I require a bit more. That's at the moment it seems to me that's what Chris is saying, what this AH thing is saying.
Well, my lord, the important aspect of that is the may. Because
Oh,
as I
may.
say, and this comes to the AH point, paragraph 85 in AH.
Yes.
If Master Campbell had followed through what appears to be the logic of that first sentence, he would say, well, the paying party must produce some material, here there is none, end of story.
Yes.
but he doesn't, no material is produced by the paying party, but there remains an issue because that issue is live on what he has in front of him, and he goes on to determine that issue. I accept reading just that paragraph in isolation, there appears to be an illogicality between the first and the second part of.
Well, I don't think so.
what the
He's
matter
saying,
says.
I don't think so, because I'm not quite sure how much of a challenge is being made. But he's saying, look, I haven't got that evidence, but even without that evidence, I've got some other material,
Yes.
which is sufficient to reduce it to some extent.
Lord, yes, and the question we say before the court is simply whether the court is satisfied on the material before it that there is an issue to be determined. And if there is, then it determines it. If not, it says to the...
Well, so it comes to no
party-
more than this, which I think is the common sense and short answer to all of this, which is, once it's satisfied that there's a genuine issue, as you put it, the judge will then decide whether it needs any further material in order to be able to resolve it. In some cases, they'll say, as in this case, I don't, and in some cases, they'll say, well, I'll need a bit more than that.
Sorry, Lord, if your Lordship would just give me one more. It's a matter of some importance, so I need to be careful that I don't say something that I shouldn't.
I quite understand.
My Lord, in broad terms, I wouldn't disagree with that. The only qualification I would add to that is once the court is satisfied there's an issue, if it's a standard basis assessment, then the burden passes.
Well, I think there's a slight contradiction of what I'm saying. I mean,
Lord, there aren't two steps to this. The court is well, there are two steps in the sense that there's a question of whether there's an issue and whether it's resolved. But in terms of whether there's an issue, the court will look and say, based on what is in front of me, is there an issue? It could turn round to the defendant and say, I'm not satisfied you've raised an issue. If you want to raise an issue, go away and produce more evidence.
yes, that's what I'm envisaging. That the court might say, this is quite a technical issue. I can see that it's not an issue I can just dismiss out of hand, but in order to resolve it, I'm going to need a bit more, and I'm going to require you, the person who's paying, to produce something more than you've done in order to assist the court, and then the defendant will, the claimant will then have the opportunity of answering. What I'm trying to push back on is, if you're making a submission to this court that once an issue has been raised which is genuine, even though the judge would like more evidence on it, that there is some rule of law that somehow, because it's been raised by virtue of the standard basis approach, the district judge is precluded from doing that.
Lord, I think the difference, if I can put it that way, between us, my Lord, is our position, I hope, is relatively simple, which is that if a genuine issue is raised, once you get to the point that the court says there is a genuine issue on this, you've done enough to raise a genuine issue, then this is just an assessment of costs like any other assessment.
This is just what?
An assessment of costs, my Lord, like any other assessment. There is an issue as to an item of costs, it must be assessed. Now the court within that assessment can say to either party, I want further evidence to help me with this. But if it's satisfied in the first place that there is an issue, the court could also say there is no issue. You haven't done enough to raise the issue.
Well, I think we're repeating what I've said. Yes, if the court says, look, I just don't think this is a genuine objection at all, I'm not even going to take it further, it goes. All I'm saying is, I thought this was pretty much obvious actually. If you're an adjudicator, the court may say, look, I think they've raised a reasonable point here. You now, the claimant, should answer this.
Yes.
Or it may say, I can see there's something there I can't dismiss out of hand, but I need to know a bit more, and indeed so will the claimant, to understand exactly the point that you're making. And then the judge, he or she, will say, I think you should do this. Well, I'm saying there's no rule of law that precludes the district judge from doing that.
My Lord, on that I wouldn't disagree.
Right.
The district judge has all the powers available to a judge to call for evidence before him. But at the risk of flogging a horse alive or dead, my Lord, the simple point that we seek to make is, if the court is satisfied that there is enough of an issue before him to require determination,
Yes.
then of course he can require evidence from either party. But
Yeah.
once that item of cost is being assessed, it falls within the rules of
No, of
costs.
course.
Yeah,
Well,
like
nobody's
any other
disputing.
item of
That's
cost.
not in dispute.
That's right. So that's that. And that's
If at the end of the day the judge may be able to resolve the matter completely one way or the other.
Yes.
But all you're saying is, if there's any doubt left in the mind of the judge at the end of the day, the normal rule applies. Well, of course.
Absolutely, Lord. That's
Right.
it.
Well, there we are.
well, that's not quite though. That's not quite right, is it? Because you're really saying you're very keen on the burden point. This will be a summary assessment of costs. The DJ might have 10 in the morning. It may be unlikely that the DJ is going to want the parties to come back again, so he'll do his best. And you say the default position is the burden,
But once,
which you say is a low threshold because it's once a genuine issue is raised.
once,
So Mr.
sorry,
Bacon has a very high threshold, ring fence. You have a very low threshold.
Well,
Once there's a genuine issue, it switches to the claimant.
Lord, we would say it is simply the threshold that the rules provide.
Yeah, well, I understand that's what you say. Yeah.
How high or low it is as a matter of practice is we would say not the issue. We simply say there's no. Once an issue is identified, there is nothing in the rules that permits or requires a different threshold because it's an ATE premium than any other matter. The test is the same. Is it reasonableness? Sorry, is it reasonable? If yes, you get it. If no, you don't get it. It's reduced or disallowed to the point of being reasonable. And if there's a
I'm
doubt-
just trying to tease out, and I think so. I have satisfied myself that I teased out to my own satisfaction where you are on this burden of proof point.
Lord, I'm sorry that you've had to tease it out, but I hope our position is sufficiently clear.
If the judge feels that he doesn't want to hear any more evidence on it because he's got 10 other cases to do or whatever, that's a matter for him or her.
Lord, yes, and indeed it's not uncommon
And
with.
if they're left in doubt, then the normal rule applies. I don't see there's a difficulty here. But the judge may say, look, this is actually quite an important point. Maybe a lot of money turns up, I don't know. And he or she may say, well, I want a bit more evidence. I mean, that's this case. This case is where more evidence was required.
Lord, yes.
It's as simple as that.
I'll rather than complicating matters further, I'll simply say yes.
Yes,
and
that's fine. Right, so any other cases you want to refer to on the threshold point, about which I think we've now got some clarity?
Lord, I don't think I need to. There are a number of other first instance and first appeal cases in there. I don't think.
Why don't you, rather than taking us to, why don't you just tell them what they are? We can.
Well, Lord, the only one I'll mention, just for your Lordship's reference, I don't invite your Lordship to turn it up unless they wish to do so, is the Murray case, which is tab 14, which is a relatively recent decision. It's a decision where the defendant's challenge to the premium failed at first instance, and that failure continued on appeal. I think it was said yesterday it wasn't a ClinNeg case. It in fact is a ClinNeg case, but it's a pre-April 2013, pre-LASPO, so full ATE, full adverse cost indemnity case. Apart from mentioning it, just to highlight the fact that I do on occasions act for claimants as well as defendants, which was that case. Lord, the only points that I would highlight are that if your Lordship's looking, I don't necessarily invite them to do so now, at paragraph 45, little 5.
What is that case?
In that case, it's page 191 within the
Well,
case.
we'll look at it in due course.
45, little 5. The only point that's made there is that there was a challenge to commission. The challenge failed. But the challenge failed because the court engaged with it. It wasn't a question where the court called for expert evidence. It engaged with it, and it was satisfied that the figure that was being sought for commission was not, as it described it, scandalous, outrageous or excessive. And the courts have got a lot of experience of what commissions are generally charged in these cases. It engaged with the point, it dismissed it. But we say that's an entirely proper course.
Paragraph 45.
Paragraph 45, little 5. The only other point I highlight is within that judgment is paragraph 50. Again, the challenge is failed. There's reference to the at least some material point, but the reason the challenge failed in that case was because the defendant did not produce any comparators. Whether if they had, they would have been good enough to get the challenge home is another issue. But the point that was made was that the defendant's challenge didn't get off the ground because they didn't produce any comparators. And as your Lordship will know, we are part of our argument in these cases we say it is that because of the nature of this market, comparators are one of the ways that we are and should be able to challenge these premiums by raising a question, raising a doubt as to why a particular cost was incurred when other claimants with similar cases and similar circumstances appear to be able to do the same thing for a lesser cost. And I put it as no more than that.
Right. So we've dealt now with that issue. Which issue do I want to go on to?
Well, my lord, I've dealt with
that was the threshold issue.
I've dealt with the threshold point in terms of, in essence, if I can put it this way, outcome. So once the threshold is passed, how should the court deal with it? Well, we say that really just is a matter for the judge on the assessment, as we saw in the Surrey and AH cases. The judge has to consider the challenge, consider the issues that are raised, use their experience and knowledge, and decide what the outcome is. Now, again, that may seem to be a burden thrust on cost judges, which is one that they would not welcome. But it's one that they do have experience to engage with, and it's one that we say is the only solution that's available if there is to be any kind of control exercised over these premiums. It has to be ultimately a matter for the exercise of the judgment of the cost judge on the matters raised before him, if he is satisfied that they are properly raised before him.
Right. I think what we were engaged in is a rather more particular issue, which is how should cost judges go about dealing when they've got a bill of costs, which is and it's their disputed items. How should it go about dealing with issues of reasonableness and proportionality? And I think what was said, but I'll be corrected if I'm wrong by Mr. Bacon, is that what they should do effectively is they go through the items, determining the question of reasonableness, which will have an overlap, of course, with proportionality, because as we know there is an overlap between the two. They're not exactly the same, there's an overlap between the two. They'll then see the overall figure at the end, and they will then decide how to make it more proportionate if they need to do that, but that, according to the case of the appellant, the ATE insurance at that point will be ring-fenced. It's taken out of the vision. That, as it seems to me, is what we're now being asked to do by providing guidance to all the DJs who are dealing with these matters.
Lord, yes, and can I come to that point? Because that's really moving into the submissions in relation to proportionality. So
do you agree with that exercise of going through each item to look at the reasonableness first?
My Lord, broadly I do. In terms of the general approach on assessment,
Yes.
It perhaps won't surprise the court that I don't disagree with much of what Mr. Bacon said on that, save when he comes to the question of what you do with the ATE.
But I think it's still useful, although you're both very familiar with this, people are asking us, I think, to give some guidance
Lord, yes.
on the way that it should be approached generally, and I think therefore it would be helpful if it's thought this is what we should be saying, is you go through it first and look at reasonableness, then you look at proportionality.
Well, my Lord, one slight gloss on that, which I don't think is any different from what Mr. Bacon was in fact saying to the court, but just to be clear, the court conducts what's the term that's used is a line-by-line assessment. So it looks at the individual items. When it is doing that, it can look at those individual items both as to whether they are reasonable and as to whether they are proportionate. Now, in practice, the majority of that line-by-line assessment will be focused on the reasonableness of the items, but, and I don't think there's any difference between myself and Mr. Bacon in relation to this, if during that process the party says, well, in relation to this particular item, counsel's fees, experts' fees, whatever it might be, not only do we say that's unreasonable, but we say it's disproportionate, then the court can deal with that question of the proportionality of that item at that point.
And I know, but the trouble is, these are rough and ready practical exercises. The thing is that there's already an overlap and Lord Justice Brooke made this clear in his case, there is an extensive overlap between reasonableness and proportionality,
Yes.
because something which is disproportionate is unlikely to be reasonable.
Yes, which is why, my lord, the prime function on the line-by-line assessment is usually looking at reasonableness, because it's only where the paying party says that the particular item falls foul not just of the lower test but also the higher test, that the court will be asked to look at not just the reasonableness but the proportionality of that individual item.
Well, here's the example yesterday of the excessive series of interlocutory hearings.
Yes.
Now that, if those are generated by the paying party, the line-by-line exercise would naturally, one would have thought, identify, was it a disproportionate series of activity, and it might well be, but it might equally be reasonable for the receiving party to have gone along with the activity. So the question of whether that series of interlocutory hearings was disproportionate would have to be done on the line-by-line, because the judgment about its lack of proportionality wouldn't depend on the outcome, wouldn't depend on knowing the overall total. So I took what you're saying is it mostly will be reasonableness, but there will be examples where the line-by-line analysis will say that activity was disproportionate. Whether the exercise of discretion arises will depend on whose fault it was. And then at the end, overall proportionality becomes a matter of consideration once you know the outcome.
My lord, I wouldn't disagree with that, save to highlight one point, which is that it wasn't touched on in the exchanges yesterday. One of the concerns raised was when you come to that end test of proportionality, the point that was being made by Mr Bacon is, well, how do you deal with that if, for example, part of those costs have been incurred as a result of the poor conduct of the paying party? Well, the simple answer to that is one of the express factors under 44.5.3 that you take into account. So conduct is built into the test of proportionality.
Can I then refine what I put to you before in the light of the exchanges we've had, which is to say that the cost judge will do a line-by-line assessment, primarily by reference, in all cases by reference to reasonableness, but where a point is made on proportionality, which does not depend on the overall size of the bill at the end of the day, then no doubt they will take that into account as well at that stage. Is that a fair way of putting it?
My lord, yes. Lord,
That's
yes.
fine.
So, and my lord, this is borne out. Perhaps if I can come to the documentation at the back of the authorities bundle, just to deal with a number of points on this. As to essentially how we got to where we are and how the test should be interpreted, because this will then take us through this point and then on to the question of taking into account all the circumstances or not when applying proportionality. So, my lord, towards the back of the bundle, tab 28, you have Lord Justice, so that's the authorities bundle, my lord, tab 28. You have Lord Justice Jackson's report, and within that you have, just to highlight the key sections, if we turn to pages 34 and 35, you have on 34 at the top a section headed comments on Lowndes. I'm not going to take your lordships all through it, but over on 35 in particular, it starts at the bottom of 34 on to 35. You can see an extract from a speech given by Sir Anthony May, President QBD as he was, in 2009 about the inadequacies of the Lowndes test, if I can put it that way. And at 4.8 you can see that it was the President who proposed at that point that the application of Lowndes should be reversed.
But everybody agrees that it has been reversed.
My lord, everybody agrees that it has been. We then have over the page on 36 through to 37, Lord Justice Jackson's proposals, and so we can see at the top of 37.510 underlined the point that was being made, which is where we come back to 44.3 and the point I made to your lordships earlier about the relevance of the word necessary in that rule. The core point was that disproportionate costs do not become proportionate because they are necessary. And so that was Lowndes, and that was what was going to be reversed. And then we see at 512, and this comes to the point your Lordship was just raising with me in relation to the approach on assessment. Disproportionate costs should be allowed in disallowed in an assessment of costs on a standard basis. If the judge concludes that the total figure, alternatively some element within that total figure, was disproportionate, the judge should say so. Disproportionate element should be disallowed in any assessment on the standard basis. Can't be saved, even if the individual items within it were both reasonable and necessary. Yes. And then at 513, this doesn't feature in the rules. So the practice, as opposed to the principle of what can be allowed, the practice was not embodied in the rules. There's nothing in the rules that tells the judges precisely how to do this, which is why your Lordships are being asked to give guidance. Lord Justice Jackson, having indicated in the previous paragraph that the court can look at either individual elements or the total at the end, then goes on to make the point that at the end of the assessment there should in effect be a stand back to apply proportionality test on a global basis.
So where are you reading from?
So this is 513, my Lord.
So he isn't envisaging doing it item by item.
Well, save that he's indicated in the previous paragraph that an individual, if there's some element within the figure. So, and I think, as I say, I don't think there's any dispute between Mr Bacon and myself on this, and I dealt with this in the submissions to the court. There's nothing to prevent, and indeed if the point's raised, the court will be required to address the proportionality of an individual item. But the line-by-line assessment will generally primarily deal with reasonableness. If there are any individual items that are said to be disproportionate, it will deal with that.
No, I know, but what
But
is
at the end...
Yeah, but okay, so there are 2 points. So we've gone through all of this, and I assume that that the ATE insurance premium will also fall to be assessed on the reasonableness issue.
Yes.
I think the question is, once it's deemed to be reasonable, that's when it gets ring-fenced. That's the point.
Well, my Lord, we would say not. First,
Right, but don't jump ahead. So I just want to... So we're all agreed at the moment, I think there's general agreement, you go through, the first thing is you go through a standard assessment, line-by-line assessment, primarily with regard to reasonableness, but in some cases where you don't need to know the total outcome, you can still say on a disproportionate challenge, you may be able to resolve that on an item-by-item basis. I think there's a general consensus about that. There's a general consensus then, I think, at the end of the day, whether by reference to what's in the Jackson report or generally otherwise, you then have the total bill and you then say, is this proportionate?
Yes.
As a whole? There may then come a disappointed disagreement. At that point, there are 2 points made by Mr Bacon. One, he says, you can't simply globally say we'll reduce the whole bill by whatever it is %. What you've got to do is you've got to have a rational and transparent process for making it proportionate. And so what you do is you look at categories of cost at this stage, and you say, well, can this be reduced in order to make the whole thing proportionate? But when you go through that exercise, he says, and this is the second point, the AT insurance premium, once it's deemed to be reasonable, that then gets ring-fenced because it is by its very nature therefore proportionate. So really what we're now asking you to do is to say, what do you say as to that part of the process?
Well, my Lord, I can indicate what our position is and then take your Lordship in a little more detail as to why.
Yes.
So firstly, in relation to the general procedure, can the court make a global reduction? We would say yes.
Right.
It is absolutely open to the court to do so without needing to go back and tease out individual items or categories. The ultimate function of the court through this new test, and I'll take the Lordship in a moment to some guidance as to what the new test was intended to achieve, but the ultimate function of the new test through the stand back that Lord Justice Jackson indicated at 513 is to step back, look at the total, and through a reasoned process of judgment, consider the totality of the costs that have been incurred against the factors in 44.53 and decide whether that total is a proportionate sum for this claimant in light of those factors to have spent on the case. And if it's not, it has to be reduced until the judge is satisfied that it is. But that has to be a process of... I entirely accept the point. The judge can't just say, you've asked for £50,000, you can have £40,000. There has to be some process whereby he indicates and identifies why spending, say, £50,000 by reference to the factors is a disproportionate sum to have spent. But he's not tied to having to do that by going back and re-dissecting the cost that he's already allowed.
What's wrong with that process? What's wrong with a process which is a plainly more transparent one? Where you say, well, it's disproportionate. I haven't actually assessed, say, in relation to some of these items, their proportionality relevant to the technique. Why can't he say, well, what I'll do is, looking at the whole, I think that the total number of hours spent on this case by so many fee earners is in the end disproportionate to what's recovered. Why can't he do that?
Well, Lord, I don't say he can't do that, but equally I say he's not bound to do that. Our point is simply that it is open to the judge to decide his own precise procedure for dealing with it. But
I'm not sure that we want to give them guidance.
Yes.
So we want to, I think what they're looking for is us to provide guidance. So would a sort of compromise position, and a pragmatic one, be this, that if looking at the whole, it seems to be the judge is satisfied that there's a disproportionate outcome. What he or she can do is look first to see whether there are categories of cost which, judged against the whole, do appear to be disproportionate. That may then make the whole thing proportionate. But this is now not in your direction. But if at the end of the day it still appears to be disproportionate, then he or she can exercise an overall judgment and reduce the bill if they feel that's appropriate.
Lord, I wouldn't disagree with that process.
I mean, and it may be that Mr. Bacon says that last element's not available, but I mean that would be a way of combining from your perspective, both, because what at the end of the day you're concerned about is that the judge should always at the end of the day have the ability to say, look, the whole thing is at the end of the day disproportionate. I've reduced each individual item as much as I can, but it still remains disproportionate. I will cut it.
Yes, well,
that's your point.
Yes, one of the purposes of this test is that it allows a judge to say, well, I don't just have to deal with this micro-analysis of each step that was taken. I can look at this and I can say the whole way that this case was conducted across the board, not just the solicitor, the experts, whatever, the whole way this was conducted was disproportionate. That's led to a total level of cost, properly considering all of the factors I'm required to consider, that is disproportionate. And in taking all that into account, I'm going to reduce that sum. And there's a reflection of that, my Lord, if we can, in an earlier decision of this court, which your Lordships have behind tab, I think it's 32, Lord. It's one of the cases...
You presumably rely upon this footnote 62, do you? To 513. That's what you rely on.
Well, my Lord, I don't think I need to. I don't think, as I say, there's any dispute between Mr. Bacon and myself that proportionality. Neither of us suggests that the test of proportionality replaces the need for a line-by-line assessment. Neither of us are suggesting, I think, that the court can simply say, I don't need to bother with a detailed assessment. It's day one of a 5-day assessment. Your bill is £500,000. I think the proportionate figures are £100,000. Everybody go home. I don't think either of us are suggesting that, though, of course, some early guidance in such an assessment.
So is it fair to say it's actually on this issue? I'm not sure that Sir Rupert Jackson actually went into this degree of detail. So I mean, he basically says you should stand back. Well, you both agree. Everybody agrees that you should stand back and consider whether the total figure is proportionate. And then it says should make an appropriate reduction. It doesn't say how that should be done.
No, he doesn't.
In a sense, what we're debating now is how that should be done.
Yes, and nor do the rules prescribe it.
Right, okay.
Could I put in one refinement? If the line-by-line analysis indicates that this or that area of cost is disproportionate, but is the fault of the paying party, then those costs have to be set aside when judging the overall proportionality of the costs. Otherwise, you'll get a distortion.
Well, my Lord, I'd phrase it slightly differently because, as I say, when applying the test of proportionality, whether it's on an item-by-item basis or globally, the court is bound to have regard to whether those costs were incurred by the conduct of the paying party.
Yes.
So however we get there, it plainly would be wrong on the global proportionality test for the court to say, well, when I was looking at the detail, I accepted those were proportionate because they were the other side's fault, but on the global I'm going to ignore that and just cut through it.
That's not right. You haven't accepted it they were proportionate because it was the other side's fault. You've said they were disproportionate, but you're exercising your discretion to allow the paying part, make the paying party to pay because it was their fault.
Well, my Lord, on whatever basis, if the court has taken into account conduct at one point,
Yeah,
it is
then that has to be set aside.
the core point is that conduct is not missing from the global proportionality test. So
That's I think in 44.35, which is the
is.
conduct of the parties.
absolutely, well, it's the conduct of the other party. It's quite specific. It's not conduct of all the parties. It's the conduct of the paying party. Just to be clear.
Then the exercise of overall proportionality is 44.35, and you bear all of those in mind. So it's not the actual amount received, for example, which we've all been talking about shorthand. What 45.35 says A is the sums in issue.
Well, absolutely, and I'll come to that point if I may, but I don't think there's going to be much in issue between us on that aspect, but I'll deal with that in a moment.
Anyway,
without wishing to avoid your lordship's
so I'm
question.
trying to do this stage by saying, so we've got to the stage where we've done the reasonableness, we've done some individualised proportionality, we've stepped back and we've looked at the whole thing, and whether or not there's a difference between you, your case is at the end of the day, one way or another, you're allowed to reduce the whole thing.
Lord,
as
absolutely.
disproportionate, right? But then you don't agree on the treatment of the ATE policy.
My Lord, we don't. And just before I come to that, can I depart with one last point on that first point, simply in case it assists the court, and it's a very short point. I directed your lordships to tab 32, which is this court's decision. In fact, my Lord, the Master of the Rolls was on the panel in this decision in the case of Harrison. It's a judgment of my Lord Justice Davis. This is, as my Lord Justice Coulson referred to it, the budgeting case. So just very briefly, the point in that case was how the court should deal on assessment with costs which have been approved in a budget. And of course, as your lordship will know, part of that approval in a budget is deciding whether those future costs are proportionate to the perceived issues at that time. What then happens when you get to an assessment at the end, where you've got to assess the incurred costs, because they're never approved, but you've got approved costs. And now the rule provides, 3.18, that if there's no good reason, those approved costs won't be departed from. And the argument in front of the court was precisely what was meant by that. Did it just set a cap, or did it mean those costs were to be allowed unless there was a good reason? And the answer was those costs are to be allowed unless there's a good reason. But at paragraph 52, the court made this observation, this point. It's the very bottom of page 4469, where a cost judge on assessment will be assessing the incurred costs in the usual way and considering the budgeted costs and not departing from them in the absence of good reason. The cost judge will ordinarily still ultimately have to look at matters in the round and consider whether the resulting aggregate figure is proportionate, having regard to 44.3.2a and 44.3.5. So even in a case where a significant element of the cost is approved cost and there is no good reason, I think it was said yesterday by Mr Bacon, that with a budgeted case you could still look at the proportionality overall if there was good reason. But the point the Court of Appeal made is you still have to do it even if there has been no good reason to depart from that budgeted figure.
But it acts effectively as a sense check. That's the exercise that's being done, and as Lord Justice Davies rightly says, so that's a further safeguard for the paying party,
Lord, yes.
just in case something somewhere has gone wrong.
Yes.
But the general point is, once you've got a cost budget figure, then that is the starting point, and therefore at the end of the case, when you're looking at a cost assessment, hopefully the amount of work involved on all sides is significantly reduced.
My Lord, that would be the hope, but the important point is, because of course you have two elements.
That's the policy.
You have incurred costs, which of course have not been approved, and your Lordship will know, your Lordship's very familiar with the budgeting process. Your Lordship will know comments can be made on those at the CCMC, but they're not subject of approval. And then you have the approved costs, and the point being here is that the court must retain not just the ability, but indeed the obligation to step back at the end.
Well, one of the reasons, one of the reasons for that is because you're fixing your budget at each stage, looking forward. But at the end of the day, it's only at the end of the day that you'll be able to see the total amount that's actually been incurred and what's exactly an issue. And so that makes perfect sense that at the end of the day you should retain the discretion to look at the whole.
Lord, absolutely. I was one of the council advocating for that conclusion, so of course I would accept that it made perfect sense. But Lord, I simply highlight it because it goes to the point as to the existence of the stand back at the end obligation to apply.
Well, I don't think there's a dispute between you. What you do once you stand back, and it may be a matter of dispute between you exactly how you deal with that, but everybody I think has agreed that yes, you stand back and you see whether there's a disproportion or not.
Lord, yes.
Fine.
Lord, can I then come to the issue your Lordship raised with me, which has been raised by the claimants, as to whether there's in effect some different treatment within that for the ATE premium?
Yes.
So Lord, in doing that, can I finish off the process of identifying how we got to where we are with the new rule, because we would say it is informative as to what the purpose of this rule was, which goes to the question of the construction of the relevant part of the rule. In other words, when looking at proportionality, is the court enjoined to decide proportionality by reference to 44.3.5, or is the court looking at all of the circumstances, not just the circumstances of the case?
So this is the issue. Is it limited to the circumstances of the case, which as I understand it is your case, or is it all the circumstances, full stop, which is Mr Bacon's?
The Lord, absolutely.
Yeah. Right.
So your Lordship has, at the very end of this section, following on from Harrison, two further documents which by agreement were provided to the court. The first is the March 2011 government's response to essentially what we've just been looking at a moment ago, which was Lord Justice Jackson's recommendations in his final report. I'm not going to take your Lordships all the way through it, but in internal pagination, bottom right hand corner, page 3, we have the ministerial forward by the then Lord Chancellor and Minister of Justice. This, of course, is a document which is presented to Parliament as the government's response. I say I'm not going to take your Lordships all the way through it, but it refers within that to the present system having got out of kilter. Over the page, on page 4...
We only need to see the parts which bear on the matter we're dealing with.
My Lord, yes. So the intention behind the proposal, as penultimate paragraph, page 4, was to allow meritorious claims to be resolved at more proportionate cost, whilst unnecessary and avoidable claims will be deterred from progressing to the court. Just in passing, just to highlight paragraphs that your Lordships might find of assistance going through, 2 pages further on, internal pagination, page 6, under the heading Way Forward, you have the general proposal to abolish recoverability of ATE, and then in the middle of that page, refinements for public policy reasons, you have a reference to the exclusion that was to be created for the sort of ATE policies that we are dealing with here, and you'll see within that the specific concerns, need to provide a means of funding to them to ensure that meritorious claims can be brought by those who cannot afford to pay for these reports in front. One change to Lord Justice Jackson's recommendations, which is to have a tightly drawn power to allow recoverability. And I think the first part of that is in fact the section that's quoted by the assessors in their report at paragraph 13. Well, moving on 2 pages, internal pagination, page 8, paragraph 14, you come to the new test of proportionality.
Which one? Which paragraph?
Lord, page 8, paragraph 14.
14,
just
yes, thank you.
about halfway down the page on page 8. New test of proportionality will be introduced. Only reasonable and proportionate costs may be recovered. This would act as a long stop to control the cost of activity that is clearly disproportionate to the value, complexity and importance of the claim. And we say this goes to our point that the prime focus, indeed we would say the sole focus of the new test of proportionality is on the circumstances of the claim. Lord, a similar point, I'll just give you, Your Lordship, the reference to meritorious claims at proportionate costs is made at the end of paragraph 32, page 15, but I don't think it adds anything. So that was the consultation response. As Your Lordship knows, and I'll take Your Lordships back to the rule in a moment to identify how we get to where we say we get to. The CPR was amended, I'll come to the amendments shortly. At tab 34, you have the explanatory memorandum that accompanied those amendments. And within that, on the second page, you have at the bottom of that second page the policy background, what is being done and why. And 7.1 sets out the starting point over the page, little a.
Mr. Paladin, is this the explanatory memorandum to the rules that were then withdrawn or
No.
revoked?
My Lord, that's the regulations. The clinical negligence regulations, there were two sets.
My fault.
One was revoked because the joint committee
Okay,
decided
as long
it
as
didn't do its job.
As long as this is to the what actually was implemented.
But this is the explanatory memorandum, not to the clinical negligence regulations that allowed recoverability of the premium, but to the wholesale amendment of the civil procedure rules in April 2013 to encompass all of the changes envisaged by Lord Justice Jackson to the extent that they were accepted by the Ministry of Justice. So, my Lord, within that I was on the third page, I think, and we had little a under the heading on the previous page, policy background, what's being done and why. A number of provisions introduced and existing provisions strengthened to bring the expense of cost management to a proportionate level and bring down the total costs of litigation. These include, and it's the first one that's the relevant one, strengthening the overriding objective to enable cost to be dealt with, to the cost to deal with cases at proportionate cost as well as justly. The test is intended to control the cost of activity that is disproportionate to the value, complexity and importance of the claim. So we say that that is a clear statement of policy intent as to what this reversal of allowance and introduction of the new rule is intended to achieve. Control costs which are disproportionate to the value, complexity and importance of the claim. So, my Lord, within that, can I then, sorry, having dealt with that, can I then come back to the front of this authorities bundle to somewhere where we've been before, tab 4, which is the rule that was introduced under the statutory instrument to which that was the explanatory memorandum. So this is 44.3, and there is a helpful note on page 3 at 44.3.1 from the White Book, which just summarises what the amendment was that was made. Might just be of assistance to your lordships at some point. So the substantial amendments, as we can see, were coming back to the rule 44.3.2a. It was the sentence at the end, costs which are disproportionate in amount may be disallowed or reduced as, even if they were reasonably or necessarily incurred.
So we're looking at the note in the White Book.
Sorry, my Lord, no, I simply flagged that up in case it was of assistance to your lordships as a summary of the amendments.
No, now looking at the rule.
But back to the rule, my Lord, on the first page.
Yes.
So the substantive amendments were 44.3.2a, the addition of that second sentence, making clear, as we have already indicated to the court, the reversal of Lowndes.
Yeah.
The second part was the addition under B of and proportionately, towards the end of the first line and onto the second. But the major addition in terms of certainly volume is over the page at 5. This isn't an amendment in the sense of adding words in. This is a whole new subsection, little 5. And I should point out, little 7 is a new subsection, but that's just directed to transitional provisions, which we don't need to worry about. But little 5 is a whole new subsection. Now, I'll come back to little 5 in a moment, but the difficulty that arises under these rules is that if we go back to the previous page again, the bit that was there previously, which is in parentheses, under 44.3.2, factors which the court may take into account are set out in Rule 44.4. And Rule 44.4 itself, which you have about 10 pages further on in that section.
Those are the general rules.
Those are the general rules, factors to be taken into account in deciding the amount of costs. Those parts were not amended, save in 44.4 on the second page for the addition of little h, which is the reference to budgets.
Just remind, where's 44.4?
44.4, it's if you follow through from 44.3, it gets to page 15 in the white book at the top right hand corner, and then over on the next page is 44.4. It's unhelpfully not internally paginated in a consistent fashion.
Yes. So you're saying that was all there before?
Yes, and again, your lordship has a little note at 44.4.1. The rule is substantively, the rule is in exactly the same terms, apart from the addition of subparagraph H, paragraph 3 of the rule. So it's little h, reference to budgets, was the addition. So what you have, and it's perhaps, if I can be so bold as to suggest, perhaps not an ideal piece of drafting, is you have 44.4, which was the existing rule carried forward, referring to general circumstances to be taken into account when deciding whether costs are proportionately and reasonably incurred, and then a new rule against the legislative policy background very clearly set out, which we have seen, which says that the purpose of this is to ensure costs are proportionate to the value, complexity and importance of the case, and introduced a new rule which says the court can only allow proportionate costs, and that costs are proportionate, little 5, if they bear a reasonable relationship to a closed list of factors, which mirror, bar some additions, but which mirror what we'd seen set out in the legislative policy. So sum in issue, added to that has been value of any non-monetary relief at B, complexity, which we saw, wider factors at E, and then Lord Justice Irwin's point that we've already touched on at D, a reference to the conduct of the paying party.
So you say that's a closed list?
I say that that's a closed list. I say it follows the legislative policy, and it sets out the circumstances in which costs are proportionate, and it is determined in accordance with that closed list.
Right, but when does 44.4 remain relevant?
Well, my lord, it remains relevant on the assessment of costs generally as to reasonableness, for example, but we would say that it is not. I accept there's something of a conflict between the two, but we would say that the new rule introduced for the policy reason given is the determinative rule as to what is proportionate.
No, but then, sorry, you have to answer that. But then, what are the words in parentheses in 44.32 do? Give me a practical situation where they would apply.
Well, my lord, they were
where they go beyond 40. Where they go beyond 44.35. Where do they apply?
Well, my lord, in terms of proportionality, we would say they do not.
Sorry, say again?
In terms of proportionality, we would say they do not.
Right,
So that the bit in parenthesis, you say what is wrong,
well,
because you say that the fact. I mean that you would agree that factors which the court may take into account is applicable on the face of it to both A and B.
Lord, I accept that it would appear to be so.
So therefore, but so you say that somehow 44 44.3.5 overrides that reference?
Well, Lord,
If you're talking about proportionality, is that the point?
In effect, yes. That 44.3.5 is a new rule which has been added, which says in terms when costs are proportionate.
What does the White Book say about that?
It doesn't.
Any other
refers,
commentators?
it refers at 44.3.3 to no guidance having been given by the Court of Appeal as to how proportionality should be applied.
This is a slightly different point.
It
I mean,
is.
obviously, it goes to that point, but this is a point of construction of the
It
rules.
is.
And so you're saying that the bit in parenthesis in 44.3.2, actually, we should, on a reading of the rules, you disregard that, not as to reasonableness, but as to proportionality, because of 44.3.5.
Well, my Lord, that is a pithy, if I may say so, summary of our submission.
And there is, just give me a minute while I note it down.
It doesn't really make much sense because 44.4 says expressly the court will have regard to all the circumstances in deciding whether costs were A1 proportionately and
Well,
reasonably
it does.
incurred, or 2 proportion. So the trouble is you're I'm not saying all wrong, but the difficulty of your analysis, which is to say that 44.4 remains relevant to reasonableness but not to proportionality, is that it not only is that a qualifying of 44.32 which you don't find anywhere else, but it contradicts 44.4a1 and 2.
It does. Well, yes, I have to accept that. It's the reason why I took your lordship to the changes that have been made and the policy behind them. Because what we have, and as I say, in my submission, the fault may lie in the drafting, but we have a new rule introduced which we would say sets out a test that applies, which appears to be in conflict with an old test which hasn't been expressly dealt with in terms of proportionality. That old test remains, of course, for reasonableness. But the apparent conflict between the two, because 44.3.5 says costs incurred are proportionate if.
But is one answer, possible answer, this, that if that 44.3.5 is a mandatory provision, so if you satisfy this reasonable relationship in relation to those items, that's the end of the matter, they're proportionate. But even in a case where it doesn't satisfy those, you are entitled to look under 44.4 to all the circumstances to see whether in all the circumstances it still remains proportionate.
Well, my lord, we would say not. We would say the proper reading of 44.3.5 is as it says, which it sets out a list of the factors which go to whether costs are proportionate.
What is wrong with the suggestion I'm putting forward to you? Well, as I said, it gives effect to 44.35. If you satisfy those, yes, indeed, it's deemed to be proportionate. That's the end of the matter. But let's say, it's not proportionate to other matters, some other aspect of it. But you can look at all of these factors, all the circumstances, to see whether it nevertheless is proportionate. What's wrong with that?
What we would say is wrong with that is that doesn't give effect to what we can see of the intent behind the introduction of this, which was to ensure that disproportionate costs are not incurred by reference to the circumstances of the case.
That's going back to the reference to the value, size and complexity of the claim.
Yes,
And I understand that as an argument, but as a policy, as a short statement of policy, that's explicable, I think. But it's difficult to identify a policy that says that you wouldn't take into account the wider circumstances.
Well, my Lord, it may depend again on what is meant, because we would say even if we're wrong on our primary construction point, which is that this is a closed list which is determinative of whether costs are proportionate, we would say the introduction of that rule, together with what we've seen of the policy that's behind it, certainly shows, when it comes to proportionality, a fundamental shift, if not to give absolute power to those factors, then certainly to give primacy in any consideration of proportionality to the circumstances of the individual case.
I mean, you want 5 to read. I'm not saying you're wrong about any of this, but you actually want 44.35 to read as follows: costs incurred are proportionate if and only if they bear a reasonable relationship to.
Lord, that was Lord Justice Jackson's original draft. That is not in the final draft. There's no explanation that I've been able to identify.
He did put those words in.
That was in the draft in his report, and I think Mr. Bacon took you to that yesterday. That was in the draft in his report.
That's what you wanted to read.
Well, Lord, in effect, yes. But there's no explanation as to why those words were taken out, as to whether that reflected any policy or whether
Could
they
you
were
just
simply
take us
viewed
back to that? So I
as
got
being
that.
unnecessary. Of course, my Lord.
Just on that, I have pointed out before that people sometimes say, well, there's no explanation for how such and such isn't in the rules. The CPRC is an independent body, and it doesn't necessarily do precisely what the government requires it to do, nor does it do precisely what Lord Justice Jackson asks us to do. I don't think that there's a need to explain. The minutes are available of our discussions, and those are then provided. So the mere fact that we decide, with great respect to Sir Rupert, that we're going to do things a slightly different way shouldn't be a matter necessarily of surprise. It's one of those things.
Well, Lord, I didn't intend it to be a matter
No,
of surprise.
I know.
There are a whole number of areas where Lord Justice Jackson's recommendations were not accepted, and before this court, certainly, one always has to approach even references to his report with a degree of trepidation.
Okay.
But Lord, the reference for your Lordship is back behind tab 28, Lord Justice Jackson's final report. Page 38, internal pagination within that. And at paragraph 5.15, you will see the proposed amendment to the CPR.
So I don't think we're actually taken to this paragraph.
Mr. Bacon certainly referred to the terms of it. I'm not sure if he took you to it, but he certainly referred you to the terms.
Right, I know what happened there. I know I haven't marked it. So he said if and only if.
If and only if was his proposal. Now, as I say, I know Lord Justice Jackson, Lord Justice Coulson's point as to why there was the amendment. We have no explanation, but we would say that the rule on its face carries, in a sense, the same effect.
All right, but don't think we develop that point any further, can we? That's your point.
Well, what it is, the second point that I made, the fallback point, if I can start falling back through my points, is that if we're wrong, as I said, about those parts of that rule being the absolute determiner of what is proportionate, then we say, nevertheless, the introduction of that rule combined with what we've seen of the legislative policy goes to show that there has been a shift when it comes to proportionality, such that even if not determinative, nevertheless primacy in consideration of proportionality is to be given to the circumstances of the case.
Yes.
And we say in those circumstances, if I can try and deal with it shortly but develop it as needed, in those circumstances, Mr. Bacon's argument, which he developed very clearly by reference to those extracts in the Rogers case that I took your lordships to in passing on the way through the paragraphs where he says that indicates that all the circumstances goes beyond. We say we're in a different area here. Matters have moved on, and that the argument that therefore you must, if you have to have regard to all of the circumstances, that in doing so, that simply leads to a conclusion that the ATE premium is therefore beyond the scope of proportionality. It is something that simply is not borne out. The court must still have the ability to exercise its powers on proportionality in relation to any item of costs, and we would say either exclusively or, if not, with prime focus on the factors in the individual case.
Exclusive or primary? exclusive or prime concentration.
Lord, yes, on the factors in the individual case. And so where that...
Just pausing there, can I ask you this question then? And it's a question I put to Mr. Baker as to what the practice, generally speaking, was of cost judges when they do reduce a bill for proportionality, what view they take about items such as which are inevitable, such as an issue fee.
Yes.
Is your case that you reduced even that?
Well, my lord, our case is that an issue fee is not outside the scope of the
You have to say
application
that.
of the test
You would
of
have to say
proportionality.
there's nothing that's outside the scope.
My lord, I do. I mean, the issue fee is... perhaps I can give a practical example of what might be said to either be individual item application of proportionality, or it could be part of the global application of proportionality where it might cover an issue fee. So say, my lord, we had a case, a substantial case, a case of very substantial value. Liability wasn't an issue, the only issue was quantum. The parties, by the time it gets to shortly before issue of proceedings, are very, very close. It's a £500,000 case, they're £500 apart. And the claimant decides, nevertheless, rather than wait to see if that resolves, to issue proceedings and incur whatever the court fee is, £10,000 or whatever it might be. We say there would, for example, in that situation, at the very least be scope for an argument that that was a disproportionate step.
No, that would be an unreasonable step.
Well, Lord, it may be unreasonable also, but it may also be disproportionate.
Why would it be disproportionate if it was reasonable? How could you possibly argue it should be excluded on proportionality if it passed the reasonableness test?
Well, my Lord, the proportionality test is a higher test, as we've discussed, and there's no reason why that...
You've given an example,
Yes.
and I quite follow that it might be unreasonable to do that, but if it is reasonable because otherwise you're not showing that you mean it, or for whatever other circumstances, if you pass that test, how on earth could it be excluded as being disproportionate?
Well, my Lord, because it would come back... The step might be reasonable in a general sense, but if on the circumstances of the case, the key point was that there remained a dispute, therefore it was reasonable in principle to issue proceedings, but the key question was, in light of the value of the case and what was, and it comes back to your Lordship's point, if I may, sum in issue at that point, was it proportionate to incur that cost in light of the sum in issue under 4435? And
That
to
may
address...
then depend on where the negotiations had got to, whether the amount on offer from the defendant was, as it were, set in stone, or whether it was simply manoeuvring and the claimant couldn't say for sure that they'd get anything.
Absolutely, my Lord, and I'm not saying it's determinative. The court would decide it on its facts and may well say, no, of course it was perfectly proportionate. But the issue, the simple point I'm making is that the issue could arise. And if I can just very briefly in passing deal with my Lord Justice Irwin's point about sum in issue of proceedings, because I promised I would deal with it and I don't think I have yet. We would accept that for the purposes of proportionality, the sum in issue of proceedings is the sum that's in issue at the time the relevant cost is incurred. So you may have a case which is of substantial value, where at that moment in time it is both reasonable and proportionate to, for example, instruct a particular expert or instruct leading counsel. If the issues in that case then narrow substantially, and the sum in issue in that case narrows substantially, that might no longer be a proportionate step. And I don't think there's anything between Mr Baker and myself on that, but I thought it important to make clear that there was nothing between us on that.
Where under 44.35 do you then deal with what they actually recover? Where does that fall under?
Well, my Lord, it doesn't. The ultimate recovery is not the test. The test is the sum in issue.
So that's irrelevant, is it?
Well, my Lord, save to the extent that the actual recovery might be said to indicate what the sum in issue was. So you sometimes have a claim which is said to be worth X, and one of the arguments, putting it very roughly, that might be run at a detailed assessment is, well, liability was never an issue in this case. You ultimately accepted £20,000. It can't therefore be said that just because you put £500,000 on the value of your case, that was genuinely the sum in issue. The outcome is an indicator of what was the sum genuinely in issue. But the test is what was the sum in issue.
ironically, if we were to include 44.43
Well, yes.
in proportionality, if that's right, then at little c, the amount of any, or value of any money or property involved, at least if one takes money not to be a narrow sense of a monetary claim, might allow a proportionality judgment as to the eventual outcome.
Well, my lord, the
It's
44.3, which was 44.4, and the factors within that, which used to be 44.5, subparagraph 3, were dealt with by this court in Home Office and Lowndes, and Lord Wolfe made it clear that considerations of the value of the case under that test had to be done by the reasonable valuation placed by the claimant on the claim at the time.
So it comes to the same thing.
So it would come to the same thing.
Can I ask you this about global reduction? I think it's an essential part of your case, is this right? That you, if at the end of the day there is a disproportion which you can't, as it were, simply attribute to a particular category, then the court's entitled to reduce the bill as a whole by whatever is appropriate. Yes. When it does that exercise, does the court, or should the court, nevertheless indicate the reduction for each category?
My lord, no, we don't say it.
Well,
we say it can, but we do not say it's required.
Well, how will that work where you've got an arrangement? I'm trying to think about, if you've got an arrangement, let's say, between the client and the solicitor, that the solicitor will only be entitled, that the client will only have to pay for what's not recovered, for example, from the other side. There's some sort of fee of that sort. If you don't know what part of that bill has been reduced for any particular category of case, how are they going to be able to work that out?
Well, my lord, ultimately that's an issue between solicitor and client, and for example, it arises not just in the context of assessment, it arises, for example, when defendants accept global offers or when they accept a figure for their costs, which is most cost cases, for example, which don't go to assessment, settle not by the defendant making an offer for profit costs, an offer for ATE, an offer for this, an offer for that, an offer for the other, but by the defendant making an offer for X amount for your costs. And when that's made and accepted, and thankfully, that's how the majority of cost disputes are resolved, not by detailed assessment. When that's made and accepted, it is then for the claimant and their solicitors and their client to work out how to apportion that, and if there's a dispute, certainly in relation to some CFAs and agreements like damages-based agreements, there's quite often a dispute resolution procedure within that if they can't resolve that between themselves, there's the ability to get somebody to determine that. But that my lord, we would say is no different to, as I say, simply accepting a Part 36 offer for your costs.
Yeah, but I can see I can see that where you're deciding what or not you want to do, there could be a debate or discussion beforehand, perhaps, between client and solicitor as to how that will translate into whatever consequential matters there may be, as solicitor's costs and so on. But where the court itself, if you're right, has the power simply to say, well, we can't attribute it to any particular item, we don't actually have to try to do that, which I think is your case, you don't actually have to try to do that. We just say we're going to cut it in half. I mean, that places the client in an extremely difficult position, doesn't it? If you've got one of these conditional agreements of that kind. I mean, just to say, well, they'll have to work it out between themselves, because in that situation, there may not be a dispute resolution mechanism.
Well, my lord, as we say, ultimately, if a lump sum, whether by way of court award or agreement or otherwise, is provided to the claimant's solicitor for costs, then that is an issue for them to resolve between themselves. There are, as your lordship will know, there are court procedures, if necessary, for the question of the client's costs as between him and his solicitor and disbursements to be resolved if need be. But as a matter of practicality, it will be resolved in the majority of cases between the client and the solicitor. But we can't, Lord, we would say that cannot impose an obligation, doesn't prevent the court from doing it. So the party said, well, Master, in this case, you're going to make a global reduction, and this indeed sometimes happens.
No, that's true. But that concern or difficulty might be a reason for saying, well, you really can't reduce a court fee.
Lord, we would say not, because if it's a genuine concern, of course, the court can be asked to address it, and it would be open to the court to say, well, I accept that's a genuine concern. So in this particular case, I'm prepared to identify, at least, for example, the claimant might say, look, we're not really bothered about the division between solicitors and counsels fees or whatever, but we've got a particular expert here or whatever, and we would like to know what, if anything, within this is allowed for the expert. And the judge might be prepared to say, well, in those circumstances, I'm prepared to identify within that global sum what I had in mind for that and what I had in mind for others.
But if he's doing it on the overall basis, I've looked at everything to see if it's reasonable, I've reached that conclusion there. B, I've looked at everything line by line to see if there's a disproportionate expenditure of time or whatever. Comes to the conclusion that on that basis the whole bill is allowed at X. Then he looks at the overall outcome of these considerations as to the overall outcome and says, I think it's 20% too much. Where does that leave the solicitor? Where does it leave the client?
Well,
Where does it leave the HHJ insurer? Nobody knows where that 20% should be applied.
well, my Lord, no, they don't in that situation. And as I say, ultimately that is a matter to be resolved between them. They have received, just as they would have done if they reached a settlement, they've received a lump sum on costs which has to be apportioned.
Right, and you've got your answer on that one. Right, that's it. Is that it?
Lord, that is, I think, largely it. I think I've answered your Lordship's question in relation to ring fencing.
Yes.
Your Lordship has my submission in relation to that. So unless your Lordship wants me to do so, I won't address the Malmstead case, which identified the idea that there should be ring fencing. My Lord, beyond that, can I just perhaps deal with the 2 points that were made, two labels, if I can put it this way, that were put on the ATE premium as part of justifying or seeking to identify why it might merit different consideration. And the first was the use of the term inevitability, that in some way it's an inevitable item of costs, therefore must be treated differently. Apart from making the what might be said to be the trite and obvious points, that of course none of that forms any part of the rule, we wouldn't accept in any event that an after the event insurance premium warrants the title of inevitability in the sense that it was being used. An AT premium may well be something that in all or the majority of cases a claimant reasonably requires for the purposes of their case. But for example, in clinical negligence cases, that could be said commonly, for example, of an expert report. An expert report might be, in that sense, an inevitable cost of pursuing a clinical negligence claim, even if it only goes to condition and prognosis. Indeed, it could be said in anything other than small claims cases, in something like clinical negligence, that it's inevitable that you're going to need the assistance of a specialist solicitor. All of these matters, though, involve, and it comes to the second description that was put on this, the second label, which was referred to, which is the difference between those matters which involve an exercise of judgment and those which don't. All of these matters, the decision of whether to instruct an expert, of which solicitor to use, and indeed of whether the cost of doing so is worth bearing in the circumstances of the case, all of those matters do involve, we would say, an exercise of judgment. Should I instruct this solicitor at this particular hourly rate or not? Should I instruct this expert on my solicitor's advice at this cost or not? Should I accept my solicitor's advice to incur this particular ATE premium at this cost in the circumstances of my case? And so we wouldn't accept, Lord, for those reasons, either that supposedly inevitable costs fall outside the scope of the proportionality rule, or indeed that these premiums fall within whatever description of that type is.
You're not, but as long as so far as you're concerned, as long as the bill is reduced to what is proportionate, it doesn't matter to you which part of the bill it falls on.
No, Lord. We would say, when I say no, I'm agreeing with your Lordship in the sense no, it doesn't matter. In that sense.
The important point you make from a pragmatic point of view is the one where you say, however you do it, at the end of the day, the whole bill should be reduced until it's proportionate. Actually, from your perspective, providing you get home on that point, it's totally irrelevant to you whether or not the ATE is allowed in whole or not. You're only concerned with the ultimate total cost.
Well, provided the ATE is not held in some way to be inviolable in relation to the test of proportionality, then ultimately, as long as all of the costs are subject to that test, yes, I think that's probably right.
I'm making a slightly different point. You're coming up with I'm saying it doesn't matter to you whether on the correct analysis or not, the ATE, like some other costs, such as issue costs, are taken out of the equation at the proportionality stage, provided that the bill as a whole is reduced in one way or another. In other words, if the court simply says, well, those are taken out, but everything else has to be reduced to such an extent as ends up with a proportionate cost of X, it doesn't matter to you.
Well, my Lord, it would matter to us if what then happened was that the ATE, untouched, if it was appropriate to do so, was brought back in.
ATE insurance, as with the issue fee, to be included in the computation of costs when deciding whether the overall costs are disproportionate. My Lord's point is it doesn't matter to you whether then later, following a reduction for global disproportion, the ATE is paid in full.
Exactly.
My Lord, what happens to the ATE as between claimant and the ATE provider is neither here nor there to us, absolutely. But our point, well, your Lordships have my point, that the ATE is not beyond the scope, whether it be on an item-by-item basis or on a global basis.
Yes, and I was going to say, your concern simply is you look at the bill as a whole for all the costs incurred, with no item being excluded. That's the point.
Yes.
That's the point you're making. But if the court decides, if we say the way the court should do it is actually to apportion the reduction to make it proportionate to particular items, that doesn't matter to you. As long as the court does that, it doesn't matter to you.
Lord, if the court was to say, yes.
Because that was the point I was putting to Mr. Bacon, that the Law Society might be rather upset about that. And the Bar Council might be rather upset about that. But yet it doesn't matter to you.
There may indeed, there may be a number of parties who are not here today who may have a view to express on the approach suggested by Mr. Baker. But no, indeed, as I understand it, it may well be, as a matter of practice, the global approach is one which is, in some cases, more suitable rather than us having to know how it's being divided up. Yes, my Lord, I wouldn't disagree.
Your main point is that the ATE, like fixed costs, should be included in the total sum that you're looking at.
My Lord, yes.
In terms of proportionality.
Absolutely.
How it's then reduced isn't as long as it is reduced, it doesn't matter to you.
My Lord, yes, and so never trust counsel when they say just to be clear, but our case is, it is there to be attacked on an individual basis by reference to reasonableness and proportionality, and it forms part of the overall test at the end.
Thank you.
My Lord, the only remaining point, I think, is to tie all of this back to the judgments in these cases. Now, it may be that your Lordship doesn't need me to delay on that to any significant degree. If I could just perhaps indicate briefly, the judgment, as your Lordship knows, in the West case, it's set out in His Honour Judge Smith's judgment, page 348, paragraph 11, was that by reference to the lamp comparators, that there was an issue as to whether the cost the claimant had incurred in this case was reasonable. He concluded that there was no evidence from the claimant to explain their choice, and in those circumstances the doubt remained and he reduced the premium. He did so, I have to accept slightly oddly, in that he allowed £2,500, which was more than any of the comparators, and doesn't directly tie itself to a comparator, but we've not sought to cross appeal and pin it back to the level of the particular comparators. Your Lordship has, I know, my point about relevance of comparators, and my point that the fact that comparators are not available because of a contractual tie is not an answer to that use. My Lord, I'm trying to deal with the point shortly, but if your Lordship wants me to go to the judgments in any more detail, I'm happy to do so.
Just
Sorry,
a point on the facts so that I have it. What did the assessors say about the lamp policies?
My Lord, the reference to the assessors, I was going to take your Lordship to this.
Just tell me what they said.
So,
Do they say they are comparable?
well, my Lord, the point that was made in relation to the West case was that they said it wasn't available as a matter of fact to the claimant in the West case, because the evidence before the court was that that scheme was made available to a particular solicitor a few days later, so there's a matter of a few days between it, and because it was only available to that particular solicitor because of the contractual time point.
Yeah.
In relation to the Demouilpied case, and I'll give your Lordship the references.
Did they go on to say that they were or were not comparable in any event?
Well, my Lord, in terms of why they're not available, that's the assessor's reasoning. There's nothing to indicate.
So not available as a matter of fact?
Not available as a matter of fact.
No separate exercises, no separate comparison exercise?
Lord, and in terms of the Demouilpied case, which I was going to come to in a moment, there were lamp comparators, DAS comparators, and an ARAG comparator. ARAG had a different policy scheme later for cases which settled for less than £7,000, which in fact the solicitor in Demouilpied subsequently signed up to, but on the evidence before the assessors didn't appear to be aware existed at the material time that this particular policy was taken out. So in relation to that, as a matter of fact, the lamp policies were factually available to solicitors at that time, but only if they were, but not to this solicitor, because this solicitor had contractually tied themselves to ARAG.
So the same point about unavailability.
Yes, although this solicitor didn't appear to understand that, and the assessors expressly identified that this solicitor didn't think that they were in fact contractually tied. So, my Lord, it just in relation to that, the references, it starts at paragraph 122 onwards in the assessor's report. They deal with the lamp point at 125. They deal with the DAS comparators at 136 through to 140, and the ARAG low value damages comparator at 147. So, my Lord, just to tie that back then finally to the Demouilpied case, as your Lordships know, the decision in Demouilpied was on the basis of proportionality. The figure arrived at was £650. And in relation to that, my Lord, that decision is going to stand or fall by reference to the principal submissions we've made as to whether it was open to the judge to conduct the exercise of proportionality. He did. My Lord, the only other point that I'm invited to make is just to flag up on the issue fee point, if it assists at all. The definition of costs under CPR 44.3, I think it is. Sorry, 44.1, I'm being corrected. Does include matters such as issues fees. So it just makes the point that...
Just 44...
44.1, I think it is.
Point one. Is the definition of costs.
The definition of cost, and it's simply the point...
Costs include issue fees and the like.
Yes, my Lord, it's simply that point, so that obviously what is subject to the test of proportionality are costs. As far as HE premiums, it's been decided in Macmillan that the HE premium is within that definition. It was simply just to bottom out that point about issue fee.
That's helpful, thank you very much.
My Lord, I'm grateful unless I can assist your Lordships any further.
No, that's fine. We will we'll rise for 5. Now let me see, how long are you going to take? Because we'd like to finish if we can.
Yes, I could finish in 15 minutes.
In 15 minutes. All right, so we're going to, that's fine, we'll rise for 5 minutes and then come back.
Thank you very much.
And as soon as they get it, I think it's just if you just say it's a series of quotations, nothing more. It's no submission. It is, yeah. Is the paragraph 17? No. So if you just say, what we've done is we've kept all quotations. Can't really see any objection.
Lunchtime finish. Yeah. Exactly, it's wrong. It's in our skeleton. The only other point I think we should like to say, part of the reason why some of this wrong is because it's based on the limit of indemnity. And we can just go to the assessor's report at paragraph, it's page 55, paragraph 191, which just says limit of indemnity is totally irrelevant. And that's why some is wrong. It's 191 on page 55. Yeah, we got that. Yeah, I think you've also got to say that they've expressed this page 57 paragraph. Yes, you might be right. Just do that as a separate one. I think it's paragraph 57 on page 200. They expressly say that it is difficult.
Those are all the previous
Surprise.
Well, can I come back really on just a few points, but start with probably the most important one, which is the discussion your Lordship was having with my friend about the appropriate test. And we seem to have got to the point where we're very helpful, if I may say so, where it sounds as though a test can be promulgated by this court in terms of the approach to take. Say for the very last stage, which you anticipated I might not be agreeable with, and I do have I think a valid point to make about this third, I think it's probably the third proposal, third stage proposal, which is you go through the bill on a reasonableness basis. You can look at proportionality as you do that. You come to the end, you look at the figure. If it still appears disproportionate, you should, under the rules, go back to categories of costs, groups of costs, areas of costs, perhaps costs incurred in time periods, whatever it may be categorised, and reduce those costs to reflect proportionality, the factors within the principal rule on proportionality, not the exclusive rule, but the factors that are in the additions to the rules, to arrive at a figure which you then, we say, conclude with. Now, your Lordship proposed that there might be then another stage where you say, well, even that figure.
Well, it wasn't my
No, it wasn't
proposal. I
proposal.
was responding
No.
to their case.
No, quite. Well, I'm not describing it as a proposal. There might. There are. Well, I just want to address the proposition that there might then be a further
Quite.
stage, and we would submit that there wouldn't be, that there shouldn't be, because when I say shouldn't be, if the judge, the assessing judge, goes back to the different categories and applies the proportionality rules to those categories, so reduces them to reflect proportionality, by definition, the job, so to speak, is concluded. You arrive at a figure which is proportionate. You can't have two goes at proportionality. You go through the items of cost, the categories, and if you decide, having looked at them, on proportionality grounds they can be reduced still further, you do so. And if you decide on proportional grounds they shouldn't be reduced, you can't then at the end of the process say, I now think they should be. And that there's a real danger there, which isn't necessary or required to make this work. You end up in not just double jeopardy, but double jeopardy. Taking the example of the...
Okay, well...
So that's...
But on that exercise, would you accept that in the exercise that you're carrying out in standing back and looking at the thing as a whole,
Yes.
which will agree to be done, at that point you are looking at a figure which includes everything defined as costs.
You're looking at the figure you've arrived at, which includes everything,
Yes.
and you go back to look at...
That's a different point.
Yes.
The first stage is you're looking at when you're looking at proportionality and you're standing back, you are looking at everything, including all sorts of... There's nothing that's excluded that would otherwise
so you're looking
fall
at
within the definition in the
costs.
rules of what are costs.
I agree. So you're looking at you're including in the figure, at this stage, things like issue fees and
Yes.
everything. But my point is, when you go back, the court then has to, in applying proportionality, is quite entitled to say, I'm not going to reduce that particular category of costs, say the issue fee or some other irreducible minimum fee, fixed fee, on the basis that it's disproportionate, because I'm satisfied it's proportionate, given it's an irreducible minimum fee, it had to be incurred, whatever the circumstances may be. In our case, in terms of the premium, the wider macro circumstances that are taken into account in determining whether it's reasonably proportionate, for example. In other words, there's no more that can be done to that item that justifies a reduction on proportionality.
Well, you've looked to see whether it's reasonable. You've gone through that. And I think you say that for the present case,
Yes.
on the basis of the assessor's report as at today,
Yes.
in relation to these block policies, once you consider that they're reasonable, which is what you say the assessors say they are,
Yes.
then there's no further reduction for proportionality.
Correct.
They are what they are.
They are what they are.
But of course, that doesn't discount that at some future day, at some future stage, somebody may have a legitimate challenge, which will then have to go through some exercise in order to see whether they are reasonable.
Yes, I accept in the future there may be other arguments, but we're trying to
There
get
may
to
be a
the point
similar
where...
exercise to be carried out in the market at that time.
Yes, I mean, it's currently, on the evidence we have it today, there's no scope on proportionality grounds to reduce this.
I think this is right, but Mr. Mayor, you'll stand up if I'm wrong. So I think where we've got to is actually that the only thing that's between you now is, as you rightly pointed out, whether or not, once you've looked at individual categories to be reduced in the light of the whole, to reduce proportionality, you might still be left, in theory, with a situation where it's still globally too high. Because I think that Mr. Mallory eventually accepted, provided you include in that proportionality exercise everything, and provided that it's reduced to whatever is proportionate, taking into account the relevant matters, he says 44.35 only. He doesn't care how it falls as between the different constituent elements. That doesn't matter. What matters to his client is that they're only going to be paying a proportionate amount.
Yes, but we say that when looked at in practice and when looked at just from the
You say logically.
if you've gone back and gone back over it and you've arrived at what you believe to be a proportionate figure, the assessing judge, she says, this is a proportionate figure I'm going to allow. You can't. We would submit that's the job done.
I understand
that seems to be a
that seems
necessary
to be
part of the test, but you wouldn't then stand back and say, I'm going to reduce it till further. We end up in the world that I started off with, which is plucking figures there in an unprincipled way, just to achieve a gut instinct of a figure. That isn't desirable at all. So far as these premiums are concerned, just as a matter of government policy, you were taken to the policy, you were taken to the consultation. I just wanted to draw your attention in terms of this point about premiums being, the word inevitable is used. I think the word yesterday was an unavoidable cost. But either way, the point with the premiums and why it's necessary to have this in regard in the context of these regulations is that the government was clearly legislating in promulgating these regulations to enable claims to be pursued. Paragraph 24 of the government's consultation, for your note, no need to turn it up, but paragraph 24 of the consultation.
Which tab do we do?
It's behind tab 33. But it's clearly that the government was concerned about the high cost of experts' reports, which can be required in clinical negligence cases before a meritorious.
Sorry, paragraph
24.
Sorry. Yeah.
So the purpose of this legislation was to enable meritorious claims to be pursued, where they wouldn't otherwise be pursued because of the cost of experts' reports.
But I think this is all fallen by the wayside now under the analysis, because once it's accepted, as both of you do now, that it's included in the overall sum by which you judge proportionality, that point really disappears.
It doesn't disappear when you come back to the test, when you go back to look at the items.
I understand, but
so
if you're right that the proportionality exercise will take account of that, you're judging each category now by reference to the overall amount, and it doesn't matter to the defendant, the paying party, how the reductions made as across it. This point falls by the wayside in a way.
Well, I'm not sure it does, because we would be saying that when you go back,
the difference between the computation of the overall bill, then the overall
the justification,
and then the application of the reduction.
Right.
They're not concerned with the application of the reduction.
No, we are.
So if you have £100,000,
You are concerned.
We are, and it's why my test, if I may say so, is so workable, because not only are you going back and looking at categories and items and making a reasoned decision about why they should be reduced still further, depending or not as the case may be, you are in that process identifying the categories, which avoids the difficulties which my Lord was expressing about how do you know Who knows which part of the costs have been allowed and which haven't?
But the issue is, it's
You achieve
relatively
both.
straightforward. You look at each segment, each part of costs. You may do a proportionality exercise along the way. If you do, and you say, well, this ATE fee is a perfectly proper ATE fee premium. At the end, you've got £100,000 costs, including 20,000 premium, and you've recovered 5,750 quid.
Yes.
And the figures in question, even at the beginning, were 25,000. Then many judges are going to say that was all along disproportionate overall, and they will look to reduce.
Yes.
Mr. Maridew says they should reduce, and he doesn't care whether that is all or the reduction is applied to the costs other than the fixed fees and the ATE premium. You do.
We do, and it's important for the world at large to understand, for the courts to express a view about how. I mean, it's quite important.
Yes.
And we would say, so just don't want to lose the point that when we go back to look at the premium in that exercise, if the judge wishes to go back to look at the premium, having determined it's reasonable, and there's no other available products and so on, he or she can go back, but would be absolutely be required to take into account the other circumstances beyond just the facts of the case that the Court of Appeal in Rogers and subsequently have.
You say
macro
44.
points.
You say 44.35 is not exclusive.
Yes.
And you say 44.1, whatever it is, 44. The 44 provisions, all circumstances still apply.
Quite.
Yes.
We do. So far as the case of Surrey is concerned, our skeleton argument, I don't need to go beyond it. In our skeleton argument at paragraph 44, we summarise the subsequent first instance case law. So Mr. Justice Foskett's decision is obviously a High Court judge decision, which has been subsequently looked at by 3 subsequent High Court judges who haven't agreed. Mr. Justice Longstaff in Pollard, Mr. Justice Spencer in Percy, and Mr. Justice Stewart in Murray. When I say haven't agreed, they've not been convinced that the approach that he took in that case could be applied in the way that Mr. Mallory seeks to apply it. So it's paragraph 44 of our skeleton argument, my lord, and we set out
44 or 34?
paragraph 44 of our skeleton argument
In relation to which case was it?
in relation to the Surrey case.
Yeah, that's the Mr. Justice Foskett case that we've seen. And then there are the subsequent.
We were taken
cases.
to it's the level of cover point, the £500,000 point, which all of the subsequent cases go back to the Chris Motor Spares approach and says expert evidence is really required in these cases. We would support that, and Mr. Justice Simons was absolutely right, and there's no reason why any of that guidance should somehow fall away when we're looking at these regulations and ATE as opposed to any other ATE policy. So far as the evidence of comparators is concerned, Melinda Jr., we thought helpfully had prepared the document which was handed up this morning, a summary of the assessor's conclusions. It's only a summary, it's literally taking the court to the particular paragraphs which we would like the court to have regard, and it's in there, and I don't think I need to say any more about it. What I would want to say, so far as comparisons are concerned, and the question from my Lord Justice Coulson about ARAG, could I just ask you to turn to the assessor's report at tab 3, because this paragraph kind of says it all for us. Tab 3 of the first bundle is the assessor's report. Paragraph 160. 160. Where this forms part of the assessor's conclusions in respect of comparing policy premiums. Perhaps I can ask you just to read paragraph 160. And it illustrates the concerns that I think were expressed yesterday by Lord Justice Coulson, that there is been this practice which we would ask the court to express a view on, of coming to an assessment and just putting a piece of paper in front of a selective, if I may say so, piece of paper, and setting hairs running. And the purpose of that, I think that my Lord has seen through it all, is to invoke this argument that, there's a doubt, therefore it's got to be reduced. And that's what's been going on. And it's got to stop, we would submit. Proper evidence, some guys, needs to be produced in order to establish some unreasonableness on the part of the receiving party on the policy that they're seeking to recover.
Bacon, that could take several forms. It must be right that, for example, if it was demonstrated and they have the records.
They're the ones who have all the records, yes.
If the, Sue Grabbit and Run have access to two different policies with two different insurers, they produce the same cover, but the cost of one is more expensive, and therefore the agency fee or any relationship with this. So the solicitors consistently, or in any case, went to the more expensive policy. You wouldn't need an expert to examine that. So there are some issues that could be challenged without expert evidence.
There are, I accept that, but in terms of the points that have been developed against us here, the proper approach is not to just produce some schedules, but to produce some sort of expert witness statement, a statement saying that we have reviewed the market, we're experts in this market, we're brokers, they do exist, and this is our assessment of the status of the market at the time the policy was taken out. You could have got this policy with the same cover, with the same bells and whistles for half the price.
Yeah.
That's what needs to be going on. Now, the assessors themselves have concluded, actually, the ARAG premium falls within the broad range of all of those that are on offer. And that's the other relevant paragraph that I wanted to just draw to your Lordship's attention, which was
It's paragraph 158.
158.
158,
158, page 45 of the bundle. It's just above the paragraph 160 that I was referring to. But there's another paragraph. There's another paragraph here. Yeah.
Those are the submissions.
Yes, no, right. There was another paragraph 200. Yes, so paragraph 200, paragraph 213. 213, Lord Justice Lewison recognised that the practice of block rating keeps premiums lower than they might otherwise be, and it was not appropriate to examine the reasonableness of taking out such insurance on a case-by-case basis. Even if it were open to us to disagree, we would not, as the weight of the evidence before us supports that view. So, in other words, the weight of the evidence supports the view that block rating premiums, they are lower.
That's a different point.
It is a different point. So 200 is that it's of course in our submissions.
Well, there's also 246.
246.
Where, following evidence from Mr. Clegg, who's the respondent, they concluded that it would, the body of evidence tended to support Arag's case that its premium across the market.
That's the one I was looking for. That's the one I was looking for. There's a, and the criticism there that Mr. Clegg's answer to this was that it was not incumbent upon the respondent, which does no more than seek to raise a legitimate element of doubt. There's the game being given away. It's just at paragraph 248, the assessors expressed a view about, you know, in a short time frame these cases don't have a lot of time to extensively investigate. And there's a very criticism at 250 about flying blind, and 251 about the NHS. Perhaps both insurers' NHS resolutions could do better, keeping challenges on detailed assessments within the compass of proportionality.
I suspect that's the best bit you've got, is my Lord has pointed out 246.
It is, it's 246 was the one that...
That's really the one.
And the...
Cost market reasonably competitive.
Yes, and I might just add one other reference. It was 90, I think it was. Paragraph, on the question of the level of the premium, paragraph 94, so this is under the assessor's conclusions at page 26 of the bundle, paragraph 90 onwards, conclusions on Arag's methodology. So this is the, was the premium a reasonably set premium? First of all, paragraph 90, they say that we do not think it appropriate to come to the conclusion that they were invited to reach, that the new premium was as deficient as Mr. Mulley submitted. They were working within limited timeframes and so on. Paragraph 94, in the absence of expert evidence, we are not in a position to say that Arag should have applied a different method or that the burning cost calculated by Arag was distorted. In fact, evidence heard from Mr. Haynes, his competitors, and even from the respondent discussed below, indicates that Arag's clinical negligence AT premium is, for a market-wide product, fairly typical. That was the conclusion I was also wanting to bring to your attention. Mr. Bacon invites us to draw the inference that if there was a serious case to answer as to Arag's methodology in setting the premiums, the respondent would have produced expert evidence to demonstrate that there was. Whilst we would not think it fair to draw that specific inference, we do agree that to form any firm conclusion on the merits of Arag's methodology, expert evidence would be needed. We have none. On the question, moving on then to the two other points, self-insurance point, for your note, well, really 3 points. One, it's not a ground of appeal, which I think I can take. Two, for your note, please read paragraph 118 of Rogers, which expressly upheld the recoverability of self-insurance in ATE costs. And Callery and Gray, which has been added to the bundle at tab 31, paragraph 63. Both cases support
Gray at,
Callery and Gray, tab 31 of the authorities bundle, paragraph 63. And we say that there's no policy decision change from the pre-April to the post-April that suggests that the self-insurance elements that the courts had held to be recoverable before April should no longer be recoverable post-April. I mean, there's just no signal of that at all. And it would be bizarre if you couldn't self-insure the premium, because it would mean that claimants who lose would have to pay the premium for the insurance. The whole point of the policy of this act, of this regulation rather, was to enable the claims to be brought without the cost burden. And hence, different routes were explored as the consultation paper shows. Solicitors might fund a case for free. They might fund the disbursements. Another way of doing it was through AT insurance. So far as the agency fees are concerned, the assessor's report on this is a hair that started to be put in place by Mr Malloy, but at paragraph 209 of the report, we'd say it's inappropriate for Mr Malloy to try and seek some indulgence from this court on this point, because the assessors in terms say at paragraph 209, page 59, the real issue is whether ARAG or other insurers exclude medical agency fees from their calculations. If evidently ARAG did not, the level of detail was not available. The very limited evidence offered by the respondent as to the degree to which such fees may make up the cost of expert reports to clinical cases offers no basis for any sound general conclusions on the point.
Mr Speaker, I don't think Mr Malloy was asking us to decide the point, or I didn't understand it. I thought he was saying this was something for which he didn't need a load of expert evidence.
My Lord, I was, both in my skeleton argument and in submissions to this court, inviting the court to decide the point. I thought, but would be corrected if not, that I'd received a fairly firm indication from the court that my invitation to do so was to be declined.
Yeah, that's quite insightful.
Well, there we are. So that deals with that. I think that largely deals with. I'll just check with those sitting behind me. But I think that really deals with the key points. Unless there's any pressing. Unless your lordships have any other questions, they're my submissions.
It's obviously a very important case, great practical importance. We're extremely grateful to both counsel for your assistance on this matter, which has been considerable. We will consider our judgments in the usual way when you receive the judgment or judgments in draft. Please agree a form of order. Any further submissions are to be in writing. Thank you very much.